Wow. Good morning, ladies and gentlemen. My name is Bongelwa Agashe, and I'll be your MC and host today. Welcome. Sure, we have a full house today. A very warm welcome to our sign language interpreters today. So we just need 2 minutes just to make sure that they're all set up. So our sign language interpreters is Miss Unati Kabe and Miss Lizeka Matlolo. Thank you so much for being here today and serving our deaf communities in this auditorium and also those who are watching online. And as we all know, the National Assembly has officially approved the sign language as South Africa's 12th official language. So let's take a moment and actually celebrate that, because that is such an amazing and significant step towards recognizing the rights of members of our communities who are deaf and hard of hearing. A very warm welcome to everyone in this auditorium. Okay. A very warm welcome to everyone in this auditorium and those who are watching us online. Thank you so much for joining us today for this very special NPA Soccer Community Dialogue focusing on Domestic Violence Act 116 of 1998 and the Amendment Act 14 of 2021, which commenced on the 14th of April. So today we have amazing speakers. We have experts in their field who will take us through discussions and case studies to really help us understand or better understand the practical implications of the amendments or the changes to the Act. So just a reminder, this session is streamed on live on StreamYard. It will also be available on YouTube. It's also available on Facebook and on our www.childmaintenance.org website. It's also available on www.lunchandlearn.org.za website as well. So without wasting any more time, we're going to start our program today. And I'm just going to welcome our very own advocate, Dion Reuters, the senior maintenance prosecutor attached to the Sexual Offences and Community Affairs Unit at the NPA Prosecuting Authority, National Prosecuting Authority. Let's give a very warm welcome to
I'm not going to say welcome since you have all been welcomed by our beautiful MC. My name is Dion Reuters. I'm the Senior Prosecutor for Maintenance in the Sexual Offences and Community Affairs Unit. That is SOCA, not soccer, SOCA. So we are part of the National Prosecuting Authority, working in the field of sexual offences, domestic violence and harassment, human trafficking, maintenance, child justice, and all of those. You'll see there are barcode scanning all over in the foyer. That is for everyone that is not being able to get a copy of the handout or get a copy of all the material that the three speakers, myself included, will be talking about. So it will not be necessary for you to Google or whatever in order to get some of this information. All of it will be available in the barcode scanning. Those of you that have a complimentary copy of our presentations that we will have at the last page of it, there are also barcode scanners that you can scan, and then we'll be able to get a copy of the NSP, that you'll be able to get a copy of paper 157, the SA Law Commission paper 148, all of those documentations you will be able to get easily available. And those of you that have handouts, in your handouts, you'll be able to follow where I am in the I'm just going to do some introductory remarks and welcome everyone over here to the NPA dialogue. And then after that, I did tell you a little bit about the NPA community dialogue on maintenance that we have every last Saturday of the month over here at the venue. And then, thank you, Eugene. Then we also, every Wednesday, Mr. Eugene Opperman have a session called Lunch and Learn, where he educates members of the public on how you can access maintenance, how you can get emolument attachment order, all of those things Mr. Eugene Opperman do every Wednesday of the month. www.lunchandlearn.org.za. You'll be able to get all of that information. I'm just quickly going to go to the introduction to the domestic violence legislation, and then I will quickly just look at the Amendment Act 14 of 2021. The SA Law Commission paper is being dealt with by my better half. I can't do all of it, so I decided a better half needs to come, and my wife, Natalie Laritas, she will deal with the SA Law Commission paper 148 and 157. I know some of you have copies of the NSP and thought that you would have been able to bring. Please bring it the 27th of May when we have our next meeting so that everybody is informed of the NSP, because I found that a lot of people are ignorant and do not know about this specific movement towards empowering women in Chapter 5, as well as all the other earmarks of the NSP. So that will be an opportunity for us to have a look at it. Pillar 3 and Pillar 5 will be discussed today. We will not be able to go in detail, but we'll just give you a broad framework of what is going on in Pillar 3 and Pillar 6 of the NSP. Mr. Arends last time said, but this is a dialogue. If it's a dialogue, then there must be conversation. So Mr. Arends, we're going to give you an opportunity to ask your questions, but only one question. If you want to ask 2 or 4 questions, you can come and speak to me or to Mr. Opperman or Mr. Kassan or Magistrate Vali. The magistrates are here, speak to them. So please make sure we're going to use them. Since the magistrates are over here, let's use them. So please congregate around them, and they will also be able to give you some of the information that you might need in case you have a burning question that you want to ask and want to get some information on before you leave. Okay, the introductory as far as the NSP and the gender-based violence, I'm not going to go in detail. My wife will be dealing with it. All I need to tell you is the domestic violence legislation started off in 1998, November 1998. November 1998, I was a public prosecutor in a small town in Oudtshoorn, and I was part of that. Nobody knew what was going on. All of us just had to implement the domestic violence legislation. And I spoke to some of my colleagues that I was at university with. And 25 years later, we are sitting with the Amendment Act 14 of 2021. So in a period of 25 years, we must get this thing right. We have been going to the Domestic Violence Act from December 1998 till we now on 14 April 2023 got the new Amendment Act. The Government Gazette says that the whole act is in operation except Section 6 that is dealing with the electronic repository system. Mr. Opperman brought that to my attention because I was in Stellenbosch, and in Stellenbosch, the court manager, Mr. Byron Williams, told me that, no, they've got their email address and all of it, just to find out, no, but it's not in operation yet, even though we got the email address. In the Western Cape, there are 56 courts according to the email list. If you go on the Department of Justice's website, DOJ's website, then you will find an email list of all the electronic repository email addresses that will be out there. It's quite easy if you know where the court is. It's going to be Stellenbosch DV at justice.gov.za, something like that is the email addresses. There are 468 domestic violence courts in South Africa. So of the 468, all of them will have an electronic repository system where people will be able to then, even over weekends or over a public holiday, will be able to apply for a protection order. Don't have to wait and get to the courts anymore. So that's how we are moving with technology, and hopefully we'll get it right this time as far as this piece of legislation is concerned. I need to warn you, please. The domestic violence legislation we need to read with other pieces of legislation, and one that is exceptionally possible and beautiful that we can use is the Amendment Act 12 of 2021. The Amendment Act 12 of 21 have a lot of things to say about domestic violence, specifically dealing with bail. And some of my colleagues asked me to say a word or two of bail. I'll say it later on when I take you to a course as far as the case law is concerned and show you practically what happened over the last few years dealing with cases in the Supreme Court of Appeal as well as in the high courts all over South Africa, what was the court's interpretation of the domestic violence legislation, specifically looking at Section 6, Section 7, as well as the warrants of arrest in Section 8. Warrant of arrest is now Section 30, is now Form 33 in the new amendment legislation. So please watch out for all of these. All of it is in your handout. You will see in the handout towards the middle, all of those forms we put in there. We're not going to be able to go in detail. We're just going to touch on Form 2, Form 6, as well as Form 33 that I would like to just quickly touch on, because the Omar Constitutional Court case made it now constitutional for us or for magistrates now. Want to specifically stress the magistrates and the presiding officers that are online. Whenever an interim order or final order is going to be given, it must go in hand with Form 8, the old Act, in terms of the new legislation with a Form 33. Meaning there must be a warrant of arrest that goes with it, because if you're going to give an interim order, if you're going to give an order and you don't give a Form 33 warrant of arrest, then it's useless for that person to sit with a piece of then it's useless for you to do it. So therefore, whenever there's an interim order, always goes with Form 33. Form 33, I'll show you later on in that handout where you'll be able to then find that. So please look at the Amendment Act 12 of 2021, and specifically the other parts of the Amendment Act 12 of 2021 that impressed me is Section 51A, dealing with intermediaries, and 51C, dealing with audio-visual links. In terms of Section 51A and 51C, you can now have an intermediary in any other case but a sexual offense case. Usually in the past, in terms of Section 178 of the Criminal Procedure Act, we only had intermediaries available for sexual offenses. Now it's going to be different. Now we can have intermediaries for any case. So even if it's a domestic violence application and you feel that I can't stand being in the same room with my abuser, then you can bring an application to the court or to the clerk and say, please, can I have the services of an intermediary in my domestic violence application? Section 51A says that in any other than criminal matters, which means for your domestic violence application, you can have an intermediary, or in the case of maintenance, if you're in your maintenance application sitting, you can't stand being with that person, you can bring an application to the court and ask that an intermediary be appointed. I did discuss it with some of the magistrates, and the magistrates told me, no, but we don't have intermediary, you have to go to the sexual offences courts. Judge Yvonne Mokora said in Bannatyne versus Bannatyne, a constitutional court case, that we need to look at innovative ways that we deal with these type of matters that are conundrums in our legislation. There's no way that they're going to have one in Wolseley. There's no way that they're going to have a intermediary services easily available in Tilburg. But what can we do? There are rooms available. There are prosecutors with laptops. There's easily that you can put 2 laptops in 2 different venues, and that laptop have an access link to the courts. I see Mr. Kassan approve of it. Thank you, sir. So I know at least if I bring my application in terms of Section 51A, Mr. Kassan will then at least approve of it for a domestic violence matter, for a maintenance matter. So it's possible that any other than sexual offences matters, you can get an intermediary and you can ask for audio-visual link. Or the NPA prosecutors can go on MS Teams, so it will be easy to sit in the prosecutor's office and testify from the prosecutor's office while your specific matter is heard in court, with the court sitting with a laptop in front of them and lead the testimony that way. We do not have to have intermediary in a sexual offences court in order to do a domestic violence case or to do a maintenance case. We don't need that anymore. So because of that, my wife said I must talk louder, they can't hear me. So let me see. Can you hear me better now? Okay. Let me use my mic. I bought it, so let me see how it will work. So, what is important for us to know is that for now, we can use intermediaries in any other matter than a sexual offense matter, whether it's a domestic violence matter or whether it is a maintenance matter or any family related matter where you are scared of the perpetrator or the person abusing you, then you can bring that application. And it doesn't have to be in a sexual offences court. It can be anywhere. It can be in Mauriceburg. It can be in the room that the cleaner usually put all those detergents and jigs and Vim and all of those things. Do we still have Vim, Cider? But in any case, all of those things, we can take all of it out and we can then make, just put a laptop there with a camera, and then that person's audio visual link can be relayed to the court. If one thing COVID taught us is to be resilient, so why can't we be resilient towards making this piece of legislation viable for people? And what I would like to recommend to the presiding officers, Mr. Valley, please help us to make sure that we get in domestic violence matters, in maintenance matters, get an intermediaries appointed to assist that lady to be able to say why she wants that amount. Because as soon as he raises his voice, then it alerts her to something else that happened in the past that somehow make her keep quiet. Then she accepts an amount that she didn't want to accept. So please, let us try and work on this. We're going to have, hopefully in future, I know there's a lot of requests for workshops on domestic violence. We will have a follow-up sometime later this year. Please just watch out online and we will then make that available. The other more important, or not more important, other important GBV legislation was the Amendment Act 13 of 2021 that amends certain provisions in the Sexual Offences Act 32 of 2007. And one of it that really impressed me is specifically the one on vulnerable groups, the vulnerable women between the ages of 25 and under 18 to 25. Because usually when a child is 19 or 20, they say, nee, sy's groot genoeg, sy weet wat hy verkeerd. But what the courts over the last few years did not acknowledge is their vulnerability. And luckily for the sexual offences legislation now, we do acknowledge that they are vulnerable. They can be used by dignitaries, they can be used by politicians, they can be used by people in a position of authority, and therefore that will minimize the consent or the fact that they will be less inhibited to then either consent to a sexual proposal or whatever the case might be. So please also look at the amendment, the Criminal Law Amendment Act 12 of 2021. There is a copy, or not a copy, there is a barcode that you can scan, then you can get the Government Gazette on the Amendment Act 13 of 2021. The Children's Act, there was a lot of excitement the 5th of January pertaining to the Children's Amendment Act, which will for now in future allow us to bring those applications for care and guardianship that was reserved for the High Court, we will be able to do in the Children's Court now. I see there's hands clapping. Just hold on a little bit, because the amendment or the Government Gazette, if you read the Government Gazette, the last page says, this will commence on a date known later on in future. I'm part of a group, and the attorneys in this auditorium, please look at Mervyn Vermeulen's group up in Gauteng. It's called Think Legal Family Law. That is an excellent group to get information, because I was already myself, and I don't see Mr. Peter Higo over here, but Mr. Higo and I were celebrating the 5th of January. The Children's Act is in operation. The aunties kan nou gaan aansoek doen vir care and guardianship in the Children's Court, just for Mr. Vermeulen to tell us, no. That if you read the last part of the Government Gazette, I just was Government Gazette, it must be in operation, just to find out that it's not in operation. So just hang on a little bit. within the next few weeks or maybe a month or two from now, the Children's Amendment Act will come in operation, which means that care and guardianship will be dealt with by the children's court. You don't have to travel all the way from Vredendal to come and do a children's court care and guardianship order in the High Court anymore. Most of those things will be changed in the Children's Amendment Act. So just hold on a little bit. We will inform you on the www Lunch and Learn group, as well as on the www.childmaintenance.org.za group. On both of those groups, we will then make sure that you get that information on how to then deal with it. So what's important is that what we need to know from today is the Domestic Violence Amendment Act 14 of 2021 is in operation for 2 weeks now, since the 14th of April. 14th of April, the whole of the act except the electronic repository in section 6, all of that specific provisions are in operation. Whenever we have legislation also coincides with policy. All those stakeholders involved in it, like the NPA, like the police, all of them also have to then say, how are we going to do it? Okay, there must be electronic repository. How are we going to do it? That's why in the Department of Justice's website, you will see that they have got a lot of government gazettes and documents that they already are making available to the public, saying how are the email addresses going to look for the 468 courts, how's the 468 domestic violence courts in South Africa, or how's it going to look for the 56 domestic violence courts in the Western Cape. How are we going to do it? Now, the how is always answered in a policy document. The police call their policy documents standard orders, national instructions. So the national instructions for domestic violence is National Instruction 7 of 1999. I did call the police to find out if they have the amended national instruction available. They are working on it. This is the final phase. They're just checking out some nitty-gritties. But within the next week or two, we will have the amended national instructions that talk to the Amendment Act 14 of 2021. So it's just a matter of time. Within the next few days, or at least within a week or two, we will have the police's updated national instruction on domestic violence, how we're going to deal with it. There was a case a few years ago, 2 years ago, in the Supreme Court of Appeal. I will mention it a little bit later when I speak about the case law and weave through all the case law. And that's a case of Visser, Minister of Justice versus Visser, where Mrs. Visser, as well as her partner, sued the Department of Justice for not issuing a domestic violence order and all the things that they've gone through. And eventually the survivor was raped by the perpetrator. Perpetrator committed suicide in the police holding cells. But what came out strong in that case is information, information, information. And that's the reason why we have this congregation today, to make sure that we make sure there's information, information, information. Ms. Batana is going to make sure that the Witzenberg community will know about the domestic violence legislation. Because if the people, the survivors, or the vulnerable groups had access to this information, then the Minister of Justice versus Visser case would never have happened. The judge said that because of a lack of information, that is the reason why Ms. Visser was raped and had to go through the ordeal that she had to go through. There's another case that I'm going to refer to, the Benny Adams case that happened over here in the Western Cape, and specifically what happened at Kuilsriver Police Station. And if we are going to be informed, then we will know where we can go and hold those people accountable that are not doing what they're supposed to. So today's session is all about information, for us to make sure that we have that information. And with that information, we take it to the next level. The activist, Ms. Batana and her group, will be able to get that information out. Where's Valdila? Ms. Valdila, the face, and her group will accept for the barter shoes that they're handing out in the Manenberg community, in the Manenberg People Center. Then they will be able to make sure the Manenberg People Center become a source of excellence, a center of excellence where people know that they can access information. So we've made this 172 pages handout available to you. Please use it. There's a lot of information in there that you can use. Please make sure that you read through it. If you don't want to read through it, don't throw it in the bin. It cost a lot of money for me to make it. Please make sure that you give it to somebody else at your church group or somewhere that will be able to access that information. At the end of the handout, there you'll see an article that I wrote in the April last month, the papers, called the Any Court Conundrum. In the Any Court Conundrum, I specifically look at what happens in a case where domestic violence court do not issue a 7-4 emergency monetary relief orders and the consequences of it, while the court, a domestic violence court, have the authority in terms of Section 7 to make emergency monetary relief orders. They do not want to do that, while Section 7, subsection 7B says they can even use the Maintenance Amendment Act to make those orders. And what we need to do is for us, once we have that information, take that information to your church group, take that information to the universities and make sure that they get this information and be able to, as the future legal practitioners, take it then a step further. We try and inculcate that in our students, because if our students know and they are the future legal representatives, then they will be able to enforce those provisions on behalf of those vulnerable people. So please enjoy today. There's a lot of information and we are strict on time. Enjoy your day. You'll only be able to ask one question. Please, if you have any other questions, please come to us and engage with us, and then we'll be able to share some more of the information. But thank you so much for coming. I'm glad we've got such a big house of people over here. We're going to have coffee in the cafeteria, and then
So I'm going to introduce our next speaker. We have our very own Mr. Eugene Opperman. He's an attorney, an attorney, mediator, and director at Opperman Attorneys. Is going to start with the session of Unpacking the Domestic Violence Act, and then after that we're going to break for tea and coffee. Thank you very much.
Good morning, everybody. Are we all still awake? Yes. Fantastic, because we're in for a rough ride with the Domestic Violence Act. Probably one of the most tedious, most terrible things to deal with when it comes to either being an attorney or an advocate, or even the legal profession, people dealing with NGOs and so forth. But yes, it is most definitely not the best of choices of legal fields that you can go into. But yes, I've been practicing law for the past 23 years, specializing mostly in family law. I'm in maintenance courts, domestic violence courts, as well as children's courts. And that is my passion. We also, like Dion said, we ran weekly presentations, webinars, free of charge for ladies during lunchtime. You don't have to take off work. Log on to the works Wi-Fi, lunchandlearn.org.za, where we discuss each and every week, we discuss a topic on child maintenance specifically, and we will be extending to divorces and to children's court matters, as well as mediation as well. Very welcome to all the online attendees. I've been moderating some of the questions that came through. Amazing. I would love the people sitting in the auditorium, full house, and as well as the online attendees to just do a small write-up and mail it through to info@lunchandlearn.org.za. And then we will be compiling a type of a newsletter after this workshop. So send me a write-up of what you do, your NGO, your attorney practice, what are you specializing to, together with the contact details. And we'll circulate that amongst all the members. It is absolutely phenomenal. It is amazing to have so many like-minded people sitting in this room, fighting for one cause and wanting to know more, and that is domestic violence. So to start off my presentation, I'm going to refer you to Constitutional Court Judge Sachs, where he said in a recent case, that's in the year 2000, it's not that recent anymore. I'm just young at heart, but yeah, in the year 2000, where in the case State versus Baloy, he made this comment, and he said that all crime has harsh effects on society. So, I mean, all would agree, we don't need to be a constitutional judge to make such a type of statement. But it goes further to say what distinguishes domestic violence is the hidden, the repetitive character and its immeasurable ripple effects on society and family life. It cuts through class, race, culture, geography, and it is more pernicious because it is so often concealed and so frequently goes unpunished. That was in 2000. So it was a while ago. And in that process of time, the Domestic Violence Act has been adapted, and there was discussion papers, and there was submissions to the South African Law Reform Commission to have the Domestic Violence Act changed in order to bring it more in line with what we need in South Africa. Because we're unique. Well, we're not that unique, but we are unique. I have the privilege to attend quite a number of domestic violence webinars, invited to speak at some of those, and those are international forums where we engage with those people and we analyze what they have. And we actually have a brilliant piece of legislation. If we compare it to people like New Zealand, Canada, Belgium even, Scotland, I've done one with Scotland as well. So we've got absolutely brilliant pieces of legislation. And then once you get to a comment like Judge Sachs and all his brothers in the Constitutional Court concurred, a statement where it actually says that all crime has harsh effects on society and it goes unpunished. And that brings me to my next question. And that would be, if domestic violence is then such a great problem, what are the constraints that actually prevents us of properly enforcing that? What are the constraints? A couple of suggestions. Scream it out. Let me hear. Come on, you can't be all asleep. What are the constraints? Training, police, courts. What else? FCS. What else? Low prevention or no prevention programs. What else? Yeah. Knowledge, education. Yes, bring it that. Yes, what else? Resources. It all goes about money and they don't have that. Yes. Access to resources. Anyone? What? Fear. Fear of who? Fear of the neighbors, fear of your husband, fear of narcissists. Victimization. Lost faith in the justice system. Religion. Interesting one. Attitudes.
The sentences don't provide a deterrent. No
deterrence. Sentence, the punishment does not fit the crime. Yes, those are all things. Those are all, what I hear is a lot of training. What I hear is a lot of knowledge, imparting knowledge, because I firmly believe that before you have access to justice, you should have access to information. Because you don't know if you don't know. You don't know what is your rights in terms of a legislation like the Domestic Violence Act. You don't know what is domestic violence, what is considered to be domestic violence. And if you don't know what happens in the community, they accept that as normal. They get accustomed to it. So they accept that as normal, and it's being normalized. Up until a stage that we as community and people sitting here, the people online, go out and advocate and say, but you know what, this is what we do. This is the education. These are your rights. Only then we could start making a change. But then the changes needs to be enforced. Doesn't help we've got brilliant pieces of legislation and it cannot successfully be enforced. We all sit with a certain set of rules. I'm going to start off with a story. I've done a lot of stuff. I've been a prosecutor. I have been a magistrate. I have been an advocate. Now I'm in the legal profession doing training and helping people. But one of my previous traits, or that I had, was doing training not only in South Africa but also in India for the Hypnosis Academy and for doing training for doctors in hypnotherapy. And I want to do something with you. I'm not going to put you to sleep. Please don't get me wrong. That would be nice. I can impart some suggestions and you can crow you can sing like Britney Spears in a washing machine, but I won't do that. But I want you, all of you, and that goes for the people online as well. You might look like an idiot, but that's fine. Stick out your hands like that, all of you. I'm not going to put anyone to sleep unless they want to. Unless they want to. Simple exercise. Right. Bring it a little bit closer. Okay. Make a gun. I mean, we in South Africa, so let's make a gun. We're working with domestic violence, so we make a gun. Make a little circle. Right, now bring it closer. So put it on your chin. Is that your chin? Some of you guys actually put it on your chin. But this is the problem that we have. We've got the same set. Everybody in this auditorium and online. I wish I could see some of the people online. We've got the same, I gave you the same set of rules, the same set of instructions, yet it was interpreted differently. Some of you guys put it on your chin, which was not your chin. That is the problem that we have. Unless we are properly educated on how to read the act, how to understand the act, only then you will find your real chin. So everybody's awake. If there's anyone that is asleep, just let me know. Right. So now we come with the common perceptions. And there's one perception that I actually have a problem with. We're talking about the Domestic Violence Act. What does it say? What does it presuppose? It presupposes violence. The people in New Zealand and the people in Australia talk about domestic harm. Isn't that a more suitable word in order to educate the people in South Africa? That's something that we probably could ask the Law Reform Commission to change, because it presupposes violence. If you ask most of the people, or most of the public in South Africa, what is domestic violence? They would say it is sexual assault and it's physical assault. But what about all the others? What about economic abuse? What about being coerced, controlled, the finances being held on to, elder abuse, exposing of a child to abuse, sexual abuse, harassment, intimidation, cyber stalking? One of the online viewers, Henry, said that he did his dissertation or thesis on cyberbullying. And I will make that available to all of you guys. He's welcome to share that and impart his knowledge, because that is also reality. The use of technology in furtherance of domestic abuse is very prevalent, but that is not even addressed. Most definitely, there's about 7 specific definitions that the Act was changed into that recognizes different forms of abuse in the new Act, the Amendment Act. The Act is quite silent on a number of things. Things like systemic abuse. Systemic abuse, abuse by courts. Bullying by proxy, where attorneys act on behalf of clients with instructions to delay the damn process, bleed her dry. That's not been addressed in any form as domestic violence. Because if that person in court, if it was a respondent and he would to unnecessarily delay the matter and act in a derogatory manner, either sexually or just by intimidating, if it was just the respondent, then he would probably be charged with an act of domestic violence. Not true? So why can an attorney, acting on behalf of the clients, and I'm going to be crucified for this, why can the attorney come off scot-free because he just acts on behalf of a client? Isn't there a judicial duty or an ethical duty on attorneys to act in the best interest? Bearing in mind that Section 28 of the Constitution that deals with the best interest of the child, because in many instances, children are involved. Even unscrupulous attorneys, and I don't say it's all the attorneys, don't get me wrong, but there are. I've met some of them. That has not been addressed by the Act at all. So if one looks at the Domestic Violence Act, the amendments at a glance, that's what we're here for, aren't we? Yeah. So I've done a comparison of looking at the whole Act, unpacking this whole Act. And about a third of the Act just deals with definitions. How boring, but yes. We will go through the definitions. I'll scan through it, and I'll tell you what is the important stipulations that you need to look out for that could be beneficial to all of us that we need to know. I've marked it in red, yellow, and orange. No, red, orange, and green. Oh, shit. And if you just have that as at a glance of the changes that was made, it looks like a damn Christmas tree. There was so many changes and adaptations to the Act. Positive, but it also made for the Act to be very cumbersome. The legislator added in certain sections, then it speaks to 2A and B and big A and small a, and then it's GG and it's AF and it's, oh, the poor attorneys needing to draft documents and the magistrates needing to write out the orders, remembering all the provisions and all the acts. They should have started from scratch and say, we repeal the whole one and get a new one. And we number it A, B, C, D, or 1, 2, 3, 4, instead of A, B, big A, small a, section, numeral 2. But yeah, that is what it is. Some of the, just at a glance, definitions has been amended quite a lot. New definitions has been brought in to address certain new forms of domestic abuse, and we'll go through that. The obligation of functionaries, that was also a new thing that was brought in. What is a functionary? Functionary is probably someone that is a social worker, a psychiatrist, psychologist, people dealing with children. Those type of people will be governed and be published in the Government Gazette. The minister has been tasked to get a class of people or to identify a class of people. Strangely enough, in some of the bills leading up to the final act, they mentioned specifically by name social workers, doctors, psychologists, people working in daycare, all those type of people, those were mentioned. But subsequently, they took that out, and they said that the minister would gazette the class of people that would be considered to be functionaries. There's obligation that was brought in, obligation to report and give information. The public, you and I, if we know of a situation where there is domestic violence or even suspect there is domestic violence involving a child, a person with disability, or an older person, there is a liability, there's an obligation on us to report that. If we do not do that, we can face criminal charges. How that would be enforced, it still remains to be seen. They can't even catch the damn criminals escaping from prison. But I will not go into there. The arrest by peace officers were quite extended or amended. Entering of private dwellings in order to get information, that was included. The application of the protection order was slightly amended. The process that you need to apply at court was slightly amended. New thing that they brought in is Section 4A, the Domestic Violence Safety Monitoring Notice, where the police actually becomes involved and they go out to your house and they do home visits and they send you an email just to find out if you are okay. And that's usually happens when the parties still share the same household. But we'll get to that. That's something positive that they brought in. The interim maintenance orders domestic violence interim orders has been changed slightly. The Act also dealt with attendances of witnesses and the credit providers or the service providers providing services in terms of internet and communications. So internet service provider can now also be kept liable. Like the court can make an order requesting them the information. You know what, did the kom die email van die pa af, van waar af kom die email? You know what, they can actually now find out and enforce and compel these service providers to give out that information. But we'll get to that briefly. Existing orders, yes. Biggest change there was that if there's the two opposing orders, you know what, the typical one, pa moet van ma moet van pa, you know what, you get those two, and they've got the same ones. Those matters should be heard simultaneously. Does have certain constraints, but that has it on the cards as well. Looking at the next load of changes, I'm just going to run quickly through them without explaining them, because we will, during the course of the day, we will explain each and every one of them so that you've got in-depth knowledge and you know what they're all about. The issuing of protection orders has been slightly amended. They've brought in the electronic repository system, not suppository. I did a presentation and I talked about the suppository system and the people just said, that's not good. But yeah, Section 6A is not enforced yet. The idea of that was to have a system where everything would link up, and the DOJ personnel, the courts would have access to a centralized database with all these. Basically also like a offenders list. That the procurement process there was typical South African government, a cerebral balls up, and they actually found out that the procurement of this, the structure of this was given to a person that is not qualified. He still runs on Windows 3 for work groups, and he has no knowledge of creating a whole system that would carry all of this. So Section 6A has not been enforced. It's not in play yet. The powers of the court has been amended. Warrants of arrest has been amended. Seizure of weapons, they gave new definitions on what is considered to be a weapon and some changes to the seizure thereof, the variation thereof, of the domestic violence interim and as well as the final protection orders. That has been amended. The Act also amended the attendance of people at proceedings at the domestic violence court. Very little people know that you're actually allowed to have 3 people getting there or going with you to the domestic violence court to offer support. The boo crowd that can actually support you and sing Kumbaya. We don't have that provisions, unfortunately, in the maintenance courts. But yeah, it is still up to the magistrate if they would allow that. But in terms of the Act, you are entitled to do that. Many people don't know of that. Jurisdiction has been slightly amended. The service of documents was addressed. Legal representation for me as the attorneys, yes, that stayed exactly the same. And not the fees though, but the legal representation. Orders to cost and directions, very important, because now the court can actually make an order if there's vexatious litigation and make a cost order against any of these parties. There were recommendations to extend this to the amendments of the Maintenance Act as well, where people could be penalized for vexatious litigation. But the South African Law Reform Commission just said, it's not going to happen, not going to happen. Appeal and review stayed the same. Some offences, yes, there was harsher sentences, like you said, as a deterrence mechanism. Application of the Domestic Violence Act by the NPA as SAPS, those are all directives that need to be published by the minister. And we'll get to those. We'll speak to them briefly because some of them are already out. So let's just get to the definitions. And this is the boring part. Sorry, guys. This is probably considered the boring part. And I promise I'll make it as interesting as possible to make it as practical as possible, because we need to understand the framework, the building blocks of this act. And if we do not understand the definitions, and you read in the act about, what is considered a child, then you can go back to the definitions and say, all right, this is what is considered to be a child, or this is what the definitions say. So the definitions are always the blueprint upon which the act was written on. And that's vitally important that we understand that in order to conduct our proceedings in the domestic violence court. First of all, what is considered to be a child? A child is anyone younger than the age of 18. Very important, very similar to the Children's Act as well. The Act speaks about people in a close relationship. Remember, domestic violence is in a family. It's a close-knit. It is a domestic environment. It is not an environment, for example, where you have problems with your neighbor. That is governed by a different act. The Harassment, the Protection Against Harassment Act. That's a different act. Do not confuse the two. They are very similar, but there are differences. There are differences. We're dealing here today with people in a close relationship. So there should be a close relationship between the complainant and any other person, while considering the degree of trust between the parties. So the courts would actually find out, what is the degree of trust? What is the level of dependence and the commitment between the parties? What is the length of time, the time length that they were in a relationship? The frequency of contact between the parties, that would play a role, as well as the degree of intimacy between the parties, in order to establish if there was a domestic or a close relationship between the parties. That is very important because you'll see this coming up right through the Act. Complainant, obviously that's the person that complains. It also includes a child without the consent of the parents or the legal guardian. Children can, on their own, apply for that without the consent. And there's also certain obligations on functionaries, which we will get to in a moment. The disclosure by means of electronic communication services, that's basically just forcing the service providers to give information, like the sending of emails to a recipient or another person, or to store that, and the whole process of the technical side of abuse that has also been addressed to a certain degree in the Amendment Act. Domestic yes. So what is a domestic relationship? Remember now, we're not working with a labor relationship, we're working with a domestic relationship. And a relationship is where they were or are married to one another. It could be in terms of any law. It could be the Swiss law, the American law, God knows what. It could also be the customary law and also by way of religion. So the Act now recognizes LGBTQ rights as well. Same-sex marriages, it recognized that. Marriages by Muslim rights, also recognized in terms of this. Even where people live or lived together, even if they were not married, also the same-sex marriages. If they are parents, then that would also be considered to be a domestic relationship. If they're family members, if they are engaged, were engaged, or even thought that they were engaged. I kid you not, it is in the definition. Even if they just thought that they were in a serious relationship, and it was not like that by listening to evidence, then that could be considered a domestic relationship as well. And it's also obviously persons that share the same house. It's obviously not your roommate, wouldn't extend as far as your roommate, unless, what you look at, if there was a degree of intimacy, like we just spoken to what is contained there. So if you've got a friend with benefits living or renting a house, that would probably go through as a domestic relationship. Probably. So this is what domestic violence looks like. These are the definitions. The definitions marked in green are those that were added as definitions. We still have the physical, the sexual, the emotional, verbal, or psychological. Strange enough, I can just get back to the psychological one. Pets are also protected under this Act. Yeah. under the auspice of emotional, verbal, and psychological abuse. If the abuser uses the pet or inflicting harm to a pet even, then that could be considered emotional or psychological abuse. And that could be defined as an act of domestic violence. So pets are also protected. Economic abuse, we'll get to that later. Intimidation, harassment. Sexual harassment, for some strange reason, was separated from the normal harassment. What the act that was brought in, what the act also brought in was related person abuse. Those are not people that are family or living in a close relationship, but it could also extend to the threats to family members of the person in a domestic relationship. But we'll get to that one as well. Spiritual abuse, that was also brought in, quite welcomed, especially with a diverse South Africa, because in some cultures they actually justify. They justify. Vrou kan maar 'n moerse klap kry. Sy wil nie worry. You know what? They justify that by means of religion, their spirituality. That was stopped. That was stopped. That was brought in. Elder abuse, although we've got the Older Persons Act, it was now also considered, and it was codified in the Domestic Violence Amendment Act, that is also considered to be a form of abuse. Coercive behavior and controlling behavior, those two were quite extended. Now, coercive and controlling behavior actually falls under a subsection of economic abuse. And so I will get to the definitions and you understand why, because it's all about money. It's all about money. And last year, one of the big banks, the international banks, had a promotion or had a campaign against economic abuse. And they had these massive billboards. These HSBC was the bank. That's free advertising for them, but okay, right. Drop my interest rate. They had these massive billboards. It was not in South Africa, though. It was overseas. Massive billboards. And they had, on the billboard, they had this hand coming out with strings attached to it. And on the strings, at the bottom of the strings, there were a lady standing there, tied up in those strings, moving forward, trying to move. And it was very visual. And the caption said, he who controls the money controls the person. And that's basically the crux of economic abuse. And by bringing in coercive behavior and controlling behavior, that just amplifies that the legislator feels very strongly about economic abuse. But we'll get to that later. Section HD. Now you can see why I said it is absolutely crazy, the numbering of the act, because now you speak to FBG, H, big A, H, oh, it's crazy, but yes, this is what we've dealt with, so we have to make use of that. One of my favorite inclusions of the act was found in HD, big D, small h, big D, under the definitions, the exposure of a child to abuse. The Act now recognizes the protection of the children as well. There's a number of things that the child is also protected, and we'll get to them, and I'm mentioning the functionaries, the obligation to report. And those, we'll speak about that in a while. But the exposure to a child of domestic abuse. So if a child is being exposed to any form of domestic abuse, where they can see or they can hear domestic abuse, or where they experience the effects of domestic abuse, then that is considered to be a form of a domestic abuse. My question to you now would be, if the father does not pay maintenance, is that considered to be domestic abuse? Technically, that would mean yes. Would we see courts being flooded to circumvent that and to get a protection order for maintenance? I think the answer might be yes. But we'll see how that goes. That is still interpretation of the Act. That's still the difference between putting it on your chin or not. At the end of it all, the conduct of an act of domestic violence must impose harm or inspires reasonable belief that harm may be caused against the complainant. If people are in a loving relationship, lovey-dovey, and they've got all these fantasies, and they've got the chains and the cuffs and stuff like that, in mommy pap raps for puppy, and you know what? That is in a domestic relationship. So in other words, some of these acts could be considered okay. If they're into it, then that could be okay. So not every act of violence, because people might like that. Sadomasochism, it's fine if you do it in a relationship. And that's why the provision was brought in to say that the conduct must harm or inspire reasonable belief that harm may be caused to the complainant. So if you feel uncomfortable with this late night spanking, then that might be considered domestic abuse. But if you had a couple of wines and a pizza and the lights are dim and you're all there and there's rose petals and there's a little bit of hanky-panky and slapping, that might be okay. That might be okay. The Act brings in, and it was under the old Act, there was still mention of emergency monetary relief, where you could get a certain amount of money that the court may order as emergency monetary relief, and that is compensation for losses before or even during the time of the issuing of the protection order. And that includes things like loss of earnings. If you had to take off work in order to go to hospital or for counseling or to court, medical, dental and related expenses, the relocation, if you had to move out of the communal home and to have to relocate, stay in a B&B or booking.com or wherever, then that could be claimed as emergency monetary relief. Expenses for household necessities, educational expenses, that was actually brought in, educational expenses was brought in as a new form of emergency monetary relief. Transportation costs as well as the psychological costs for counseling and services that might be asked for and on the application of the court order presented to court as emergency monetary relief. What the legislator now also included in emergency monetary relief was the maintenance of a child or a person with disability or an older person in care of the complainant. And that is now pending the finalization of maintenance proceedings in terms of the Maintenance Act, which is specifically mentioned. So maintenance, again, is sneakily brought into the domestic violence arena because those two usually goes hand in hand. So this is what the definitions, in short, this is what the definitions look like. There are loads of definitions that the Act deals with. More than a third of the Act deals with definitions. And that is how we're going to spend our time now. About a third is going to be spent on specifically the definitions thereof. And I'm not going to do it as a reading lesson. These are all in your handouts, which could be downloaded for the online viewers and for the people sitting here. The links are available on childmaintenance.org.za and info@latchandlearn.org. You can simply log on to there and you would have access to all these forms and all these documents with all this information readily available. So let's start off with physical abuse. We all know that. That's physical abuse. And that is the thing that usually most people go to a police station to report. I have been physically abused. And that is easy. That is easy because you can actually see the bruises. But how do you go to court saying, you know what, I've been emotionally abused. I've been economically abused. What are the police going to say? And we had that. Training of police, we had that as a question right in the beginning. How would they know that that is actually allowed? So is there training needed for SAPs? Most definitely. Have they had training? No. The Amendment Act came into force on the 14th of April. We all waited for that, but we all anticipated that it might be only towards September this year. And we all prepared for that. And then wham, bam, there it goes, 14th of April. It was just published. And nobody was ready. Nobody was ready. Trainings of judiciary, training of prosecutors, not ready. I spoke to the LPC a day after, well, the Monday. I spoke to them and I said, you know what, do you have anything in place for attorneys? They said, no. They didn't know, they didn't even realize that the act came into operation on the Friday. That is how sudden all of this has been done. And this is why these type of trainings, that's why we have about 2,000 people attending online. I just checked the stats when I did the moderation. There's about 2,000 people attending all over South Africa. So there's a great need for it because people don't know. And that's why we're here. Physical abuse, I'm not going to run it. It's not a reading lesson, although it's all in your handout. Physical abuse, I'm just going to highlight the important stuff that the provisions that the Amendment Act brought about. Physical violence, threats of physical violence has also been included in order to deprive, I'm struggling with that word, to deprive the complainant of their liberty or threatening to do so. Again, if a layperson reads this act, what does it mean you deprive someone of their liberty to do that? For me as an attorney, with 23 years of experience, I've got difficulty explaining that to one of my clients. What does it mean that your liberty has been deprived, yet it was brought into the act? Very positive in this act, what they brought about and they highlighted that is to give someone, it's also considered to be physical abuse, if you give someone a drug without their consent, and also to withhold medication. That's also considered to be physical abuse. And we see that mostly with the older people. Emotional, verbal, and psychological abuse. I'm not going into much detail there. The causes of mental or psychological harm includes things like insults, ridicule, name-calling, threats, causing emotional pain, exhibition of excessive possessiveness or jealousy. Mummy, you can't be jealous about your husband if he goes to have a dip at the bar, because that could be considered excessive jealousy. Again, in a certain context, if it is excessive, then that might be wrong. But in a normal relationship, some jealousy might be good. Economic abuse. If we can just go to the next slide. Economic abuse. So what is economic abuse? Economic abuse was in the previous act. It was there. It was probably not understood. It was brought in by the workings and the advocacy of Felicity Guest when she addressed the matter at the GBV NSP, and the definitions of emotional economic abuse, not emotional, economic abuse, was actually addressed for the first time. And then it was included specifically in the Amendment Act. So there's actually people out there advocating for that. Felicity is one of them, advocating for the inclusion and the recognition. And as a result thereof, we've got an extension of economic abuse, speaking about controlling behavior, coercive behavior, manipulation, all those things that was actually included. And those were not the legislator, the one with the people sitting in the glass towers with the big glasses and the leather strapped law books behind them. Those were people from civil society that actually advocated that and spoke to the people and said, but you know what, from grassroots level, these are the problems that we have with economic abuse. And that should be included in the act. And that is a perfect example of how legislation could actually, from grassroots, be followed right through up to being enacted in the legislation. Coming back to the definitions, economic abuse, it's all there on the slides. It might include where a person is entitled to certain things out of necessity that is being withheld, educational expenses, household necessities, mortgage bond payments, and so forth. Very interesting, very interesting. The previous act spoke about the unreasonableness and the repetitiveness of specifically economic abuse. You cannot go and ask for an order for economic abuse if it has not happened unreasonably over a period of time. Under the new act, that was omitted. It was taken out. So one single act of economic abuse would allow you, depending on all the situations and the facts of the matter, then you would be entitled to get a protection order for economic abuse. It also means the disposal of household goods without the permission. So if he drinks too much and he disposes of the property of the house, that would also be considered to be economic abuse. The use of financial resources without the permission, coercion to give over control of assets of the home. Normally what happens in the home? Who takes charge of the money? Dad does. Mom knows nothing about that. Things go sour. Mom wants to move out. Now she sits with a dilemma. She's got no information about the financials of the father, none whatsoever. And that's what also makes it difficult of approaching court specifically for economic abuse, because that is something that you have to prove. You cannot likely go to the bank and say, you know what, I'm married to this person and I want the information. I want his banking statements. There are ways and means that you could get that legally and illegally. But we stay on the side of the law at this stage. So that's difficult. Economic abuse is a difficult thing to prove, but it is possible, and it has been done quite a number of times. I have written an extensive book on economic abuse that deals with all the elements, the signs thereof. And as well as this was done before the Amendment Act was enacted. I still need to update that, but for some interesting reading material, it is in your handout, and there's the QR code if you want to scan that. Just to give you a generalized idea. Now, this has been circulated amongst many of the magistrates, specifically in the Gauteng area, and thank you for that. They actually phoned me up and asked me if they could use that. I don't have a problem with that. It's all been copyrighted. You've got the right to copy it. Go for it. Go for it. Do you want to use that term? So you can use that. It will be updated and it will be made available to all the people. Right, going on to the next definitions. Intimidation, yes, I'm not going to go through the whole process of intimidation. The only mention that I would like to make there is that even a threat of an intimidation could also be considered to be a form of domestic abuse. It also includes fear of physical violence or damage to property belonging to the complainant or another person through electronic communication. Again, they bring in the tech abuse or the technical side of abuse, which is very, very, very comforting to hear. Harassment. Go to the next slide. Harassment under the old Act. So, what do you guys understand under harassment? Anyone, scream out loud that I can hear.
Invasion of personal space.
Invasion of personal space. Following you. Yeah, okay. Yes. 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 Okay. All of that. Under the previous Act, stalking was also considered to be a separate form of abuse. Stalking is now brought into the realm of harassment, where it says it is the unreasonable following, watching, stalking, perusing, loitering. I had to look up what the mean loitering means, and it just basically means standing around for no apparent reason. But all of those acts of harassment needs to be done in such a way that it inspires belief in the complainant that they or any other person, related person, may be harmed or property might be damaged in the process. Under the old Act, they had a pattern of conduct. They said that harassment is a pattern of conduct of unreasonable following, stalking, and so forth. Under the Amendment Act, the pattern or the conduct, pattern of conduct, the repetitiveness, the pattern of behavior of harassment was taken out. So only one act of stalking or perusing or accosting without permission that inspires enough belief in you that you might suffer harm might be enough in order for you to gain a protection order. Like I said, that the legislature amended this and also brought in the repeated sending or delivering of messages or packages. Yes, take a lot. On the 14th, on Valentine's Day, I had a client phone me up. The respondent or her husband got hold of her personal details, her banking details, and he delivered 27 pizzas to her, together with a bunch of roses. And you know who paid for it? She paid for it, because he got hold of her details. That is considered to be harassment. That's considered to be harassment. Again, for the first time now, they included the tracking of people. The tracking of people using your smartphone. I don't even know where's my phone. There it is. But if you look at your phone, and I'm just going to pause just for a moment on this side because I feel quite strongly about this. It's what I call tech abuse or technology facilitated abuse. If you look at your cell phone, any one of you looking at your cell phone, how many apps are on your cell phone that actually has access to your information? If I take my phone, I can switch on my geyser. I can open my security gate. I can put on my alarm. I could put it off. I could watch DSTV. I could watch Netflix and all those. I can put on my irrigation. I can control my air cons in my house. I could actually see who's at the front door because I've got cameras in the house. Those are all things that is the Internet of Things. Those are all linked on the Internet. So what would happen in a normal relationship? Who usually sets up all this? Of course, because the husband. The man is usually the one that says, you know what, liefie, los ma, jy's onnozel, los ma. They'll do it. And then they put up all these things, and they do have all the information. So if the relationship goes sour and they break up, who's got access to everything? En it's liefie het access to alles. They can see what's happening. They can gaslight you by turning off the geyser, and you would think that you were going nuts. They were going crazy. So the tech abuse is something that needs to be expanded, that needs to be talked about, because it is very, very, very prevalent. These Fitbit watches, these smart watches that you use, there's no security whatsoever for people with that. So if the husband wants to find you, he can just simply log on to your Fitbit account and he can see the route that you're running. He can wait for you. Or you can get somebody else to wait for you. So that is vitally important, that we need to have more discussions specifically on tech abuse, because it is something that is very close to all of us. Smart TVs. We've got smart TVs, we've got PCs, and everything gets smaller and everything is done from the PCs or from the cell phones. Just another thing, a way of a tip. People having Apple phones, you know what? You get a new phone, you upgrade the phone, and you don't change the password. Dad finds the cell phone, he logs in, he's got all your information. Easy. I had clients stuffing in COVID cameras in baby toys, nanny cams. Easy. That's a way of controlling coercive behavior, because they've got full access. That's an act of domestic violence, but it needs to be expanded a little bit more, and that we will probably see in future legislation for sure. I've dealt with the electronic communications where they receive or they're sending out of degrading and abusive languages. That's basically sending out WhatsApps and so forth. For some weird or wonderful reason, sexual harassment, the legislator thought that should be a separate act. I still think that it is a form of harassment. It should not be made separately, but yeah, it is like that at this stage. And that is the unwelcome sexual attention or the unwelcome explicit or even implicit, implied behavior, suggestions, or gesture or remarks of a sexual nature that has the effect of offending or intimidating the complainant. Again, if your boss touches your behind in a working situation, can you apply in terms of the Domestic Violence Act? No, because it's not people in a close relationship. Then it's that is governed by the Harassment Act. So very clearly distinguish between what is happening in home, in a family setting, as well as the workplace. It also means the implied or expressed promise or reward, if they complied with that. Again, if you sleep with me, I will give you maintenance money. I had a couple of those cases. Yes, that's sexual harassment. Friends with benefits, absolutely, exactly. As well as threat or reprisal made to if they refuse to comply with any sexual conduct. Ooh. Next slide, why is it not? Oh. We are nearly breaking for tea. I just want to stand still with the Act mentions all over that it is usually abuse against a complainant or a related person. And I think it's important that we understand what is meant by this, because this is brought in new to the Act, and it's vitally important that we understand that. Related person means any member of the family or the household of the complainant or a person in a close relationship. So a related person is somebody that is any member of the family. It is not necessarily your spouse, because if we think about domestic violence, we usually think it is about the mom and dad in the household. But it could also be extended to any member of the family or the household that is in a close relationship. And we've dealt with the provisions of what is meant by close relationship by looking at the degree of trust between the parties, the dependence on and the committance to the other person, the time period that they are in a relationship, the frequency of contact between the people or the parties, and then the degree of intimacy between the people. Where am I now? This one, yeah. So what does it mean? Because the Act says related person abuse is also considered to be an act of domestic violence. So related person abuse means to threaten the complainant with the causing of physical violence or damage to property or to themselves or a related person, or even to threaten a relation person with physical violence or causing damages to their property. So it need not only be your own property that is in danger. It could be somebody else's property. So if the perpetrator or the abuser threatens you to damage your aunt's property, that would be considered to be related person abuse. If we go to the next slide, I basically dealt, now remember in the beginning I said that there's two wheels of definitions. We're basically halfway through. It's a lot. We're basically halfway through. Do you want to venture on or take a 2-minute or 3-minute body break? What time is it now? 11:15. I think we'll break for tea, and then we're going to motor forward. So we're going to break for tea for 25 minutes. Please be seated within 25 minutes so that you do not disrupt the whole proceedings. We'll be back shortly for the online viewers as well. Spiritual abuse was also included into the new Act, which I think is quite good. And specifically in the section C, it was mentioned the manipulating of the complainant to justify the abuse. Like I mentioned, certain cultures actually allow for some panel beating, but for now, it is not allowed in terms of the Domestic Violence Act. Also included in the Act now, under spiritual abuse, is advocating hatred. So you cannot advocate hatred against the complainant for having a certain type of religion or preventing them from exercising their right of religious freedom. Damage to property was slightly amended, which now also includes the threats to damage to property. So not only is it needed in terms of the act that the abuser physically go out and damage the property, even threats of the damage to property would be considered to be an act of domestic violence. Elder abuse, I've mentioned that. The Elder Abuse Act has been in force since 2006. But for now, the legislature thought it well to also include that as a form of domestic violence. Now we come to next slide. You just get to the slide. To something that was brought in as an extension of economic abuse, and that is called coercive behavior. Now, coercive behavior and the definition, now think of the lay person, the person reading this act, and they want to find out what is the definition of coercive behavior. It means to compel or force a complainant to abstain from doing anything that they would have a lawful right to do, or to do anything that they have a lawful right to abstain from doing. Now, I mean, I've been practicing 23 years, and I have difficulty understanding a simple sentence like that. How is it expected for the lay public to understand that? Coercion. Controlling behavior, that has also been brought in as an extension of economic abuse, and that has the ultimate goal, the idea of controlling behavior, is making the complainant dependent on and subservient to the abuser. We see that in terms of narcissism. We call it manipulation. It's controlling behavior, making the complainant dependent on or subservient to the respondent. And that would include certain things, like isolating them from their sources of support, preventing them from working. You stay at home, look after the kids, I'll earn the money. That could be considered to be a form of controlling behavior. Exploiting their resources or capacities for personal gain, taking the SASSA card. Classical example thereof. Depriving them from their means needed for independence or the resistance or the escape. And this is vitally important because how many abusers, how many women stay in an abusive relationship because they simply do not have the means or the capacity, the financial means, in order to escape? That is considered to be controlling behavior. And then the last one under controlling behavior is regulating their everyday behavior. Now, I had a difficult question that I had to answer because one of the Muslim ladies came to me and they said, but you know what? I feel uncomfortable using the whole burqa and everything and the closure of the face. And it's part of my religion and I respect that. But that is controlling my everyday behavior. Would that be considered to be controlling behavior? Is that an offense in terms of the act? And that was quite difficult. And I think there needs to be some discussion and some clarification on this because it is something that you cannot exclude to a certain religious group because there might be, the Hindus might have a different view on expressing their religious freedom. The Catholics, the Christians, all of those. So that is something that definitely needs to be addressed in a cultural context. At present, there is no clear answer to that. But most definitely, if you look at the strict wording of the definition, that would be considered to be an abusive act. The one that I'm very happy about is the exposure of child to domestic violence, means to intentionally expose a child to see or to hear domestic violence or to experience the effects of domestic violence. And I was very happy that that was actually brought into the Act. And I think we might see this in the domestic violence courts coming forward more often. Entry to property, that's quite self-explanatory. And then the last portion of the definitions, where it says, you know what, all of these magnitude, this whole grocery list of possible offenses or possible definitions dealing with what is considered to be acts of domestic violence. It could also include any behavior of an intimidating, threatening, abusive, degrading, offensive, or humiliating nature towards a complainant, where such conduct harms or inspires reasonable belief that harm may be caused by the complainant or caused to the complainant. So in practical terms, any type of behavior, any type of action that might be degrading or offensive or humiliating, that has the opportunity or the potential to conduct harm or inspire a reasonable belief in harm, could be considered to be an act of domestic violence. Now, if we think of our own relationships, how many times do you think that your spouse or your partner could actually invoke this? How many times have you done something that could harm or inspire reasonable belief of harm caused to that other person? So this is very wide, and I think the courts will look at this cautionally, and they would look at certain patterns. They would look at it holistically over a period of time, and not use this any behavior type of offense or abuse in isolation, just by looking at a certain circumstance that happened, but over a period of time. Now we come to the good stuff. The good stuff. Now we're coming to, the Act is not very long. The previous Act was a couple of pages. The new Act is a little bit more, dealing with some nitty-gritty pertaining to procedure and the powers of the police, which we'll get to, the power of arrests, the duty to assist, and so forth. Those are all the things that I will highlight in terms of the new legislation that came through. A section that stayed exactly the same with Section 2, where it brings an obligation on SAPS to when they go to a scene of a crime and has been reported, that there is an obligation upon them to offer assistance. They have to give you a Form 1 document that explains your rights, that explains to you that it is a domestic violence matter, and these are your rights, and they have to assist where possible by giving you a list of shelters. The shelter list is available. It is not accurate by a long shot, but it is available, and they should, in terms of the law, in terms of Section 2, they have to assist the complainants, and they also have to explain that they are allowed to have criminal prosecutions initiated. Now, one thing that you guys should remember is that the application for a domestic violence interdict has absolutely nothing to do with opening a case at the police station. It is not necessary for you to firstly, as a first point of entry, to go to a police station to open a criminal case before you go to a domestic violence court with your application for either interim or for a final protection order. So those two stand separately. The application for interim maintenance, you see, I'm so prone to thinking of maintenance, for an interim protection order absolutely stands separately than the criminal investigation. This is just a typical form that they use. That is contained in the Form 1. I'm not going to go through the Form 1. That is a prescribed form. It is under the resource tab of the links that the online viewers might have had and the attendees here as well. You can download all these forms there. They are available. It is in PDF format, and there you would have, there you can see what it looks like, the Form 1 that is needed by the, should be given to the police. With regards to Section 2A, that was a new section that was brought in. And it basically says that the minister may, by publication in the Government Gazette, publish a class of people, a number of people that would act as functionaries. Those are usually professional people. In the previous, leading up to the final act, in all the drafts, in the previous drafts, like I mentioned, they specifically said it is social workers, it is psychiatrists, it's psychologists, all the people working in that type of domains, working with people in a violent situation. Those are all considered to be functionaries. And then the legislature decided, you know what, if we had to change social workers, or we need to include somebody else, a mediator or whatever, then they had to change the whole act, and that would be difficult. So they rather said that the minister, by way of publication on the Government Gazette, it's easier to change that by means of it being gazetted, and then the functionaries would be published in the Government Gazette. So a functionary, in terms of section 2A, now we come to the crazy numbering, the 2 big A, a functionary in performing their duties or functions, and they obtain information which causes them to believe or suspect that there is danger to a child, a person with disability, or an older person, must report that. It's not a may, it's not a if I so wish. There's an obligation. They must report that to a member of SAPS or to a social worker, and then they must do a risk assessment, and they may refer them for additional services, counseling, and so forth. So there's an obligation on them. Strangely enough, there's no criminal penalty here. So if you don't do that, you can go to jail. That's not here. And the reason for that is simply, as I understand the white papers and all the reasoning and explanations leading up to this, was that there might be criminal sanctions. If it is a doctor or a registered nurse or a mediator or whomever will be classified as a functionary in terms of the Government Gazette, there would be disciplinary action that could be taken to them. Which brings me to the next portion in section 2, big A. I could just mention before I get there that if a functionary, if this social worker or this doctor or this mediator or even the psychologist, psychiatrist, if they give their report and they give the information in good faith, because they believe that there was injury to a child, person with disability, or older person, then they would not be liable to any criminal, civil, or disciplinary charges, and they can request that their identity would be kept secret. And that's just in a way where the legislator provides a platform where the reporting should be anonymously, and it should be easier in order to protect specifically vulnerable groups like children, people with disability, and the older people. For our purposes, people sitting here, strangely enough, attorneys will not be included, as I see it, as functionaries, so we're quite safe. But the attorneys would be considered adults, well, most of them. In terms of section 2B, where it says that any adult who knows, believes, or suspects, or have reasonable grounds that domestic violence has been committed towards, obviously a child, person with disability, or an elder person, must, you have to, you don't have a choice, you must report that to a member of the police. Obviously, there would be a prescribed form, that's prescribed form number 3, and you must give reasons of your suspicions of the abusive relation or abuse that took place. And if you are bona fide and you do it in good faith, then you would not be open to any criminal liability or disciplinary action, and you might be, and your identity might be kept secret. The drawback to this is that if you do not do that, if it's found out that you knew about that and you did not report that, you could face a criminal sanction of an fine or a 3 months imprisonment sentence. So you could be sent to jail. And that was just for dramatic effect. We've got load shedding again, probably. The 3 months, yeah, somebody is not liking that, going to prison for 3 months. But I can proceed, not a problem. I cannot proceed. The online viewers are still, we still have a certain kind of a backup here. We're just waiting for Advocate Reuters to switch on the lights. interpreter might have a problem being seen for the online viewers, but we'll proceed in order for time purposes. That brings us to section 3. That has been amended slightly, and that deals with the arrest by peace officers without the warrants. I can't even see who's talking now. Load shedding. Section 3 deals with the arrest of peace officers without a warrant of execution. Now, that is before you actually entered the whole process of applying for a protection order. Section 3.1 says a peace officer, and that is exactly the same as the previous act, and I think it's important that we get the distinction here. Section 3.1, there we go with lights. Thank you. Section 3.1 says that the peace officer, upon reasonable suspicion that an act of domestic violence has been committed, in terms of any law, so that there was a crime committed, they may arrest. So they have a discretion. They have a discretion. And that's a problem that we have with the police, because they invoke this discretion. Right? But to our aid, section 7.2 has been changed to say that if there's a reasonable suspicion that the act of domestic violence was committed and violence was part thereof, was an element thereof, they must arrest. They don't have a choice. They have to. Again, there's a split, because what happens, being hit by a Noritaki plate in terms of physical violence and being subjected to emotional abuse, that brings you to a point that you actually crack now and you just lose it. What is the difference? Why is it necessary for the legislator to actually differentiate? It should actually read that if it's serious enough, that they should arrest. If it's a peace officer that is not a member of the police in terms of section 3.3, who responds to a scene of domestic violence, they have to arrange for medical attention. They have to advise on the procedure that needs to be followed if you want to obtain a protection order, and explain the remedies of what is in effect what it means by having a protection order, and to advise you to possibly institute proceedings in terms of the Criminal Procedure Act. And they have to give assistance in terms of section 18B, which we'll get to later. Yes? Sorry? Peace officers is normally, it could be members of the South African police officers. It could also be justices of the peace. It is someone that is appointed by the minister as a justice of the peace. I think I'm under correction. I think the correctional officers at the Department of Corrections also has that authority to do that. Right. I actually need the visuals. Can they just put on the projector for me that side, please? Because we're dealing now with, and I'm going to proceed without the slides and the visuals. We might get back that for the people in the auditorium. But for the online viewers, they would have access to that. So how do we apply for a protection order? Very important is that we need to distinguish between two types of protection orders. It is not a protection order that you get by default. You go to court, you get an interim protection order, and then there's a final protection order. And the people going to court, the applicants going to court, do not know, they do not understand that you first have to apply for an interim protection order before a final protection order is granted. They think, you know what, I still have the interim one, and then there's no need for me to appear later on in order to make that a final order. So it needs to be a clear distinction and a clear understanding that it is a dual process. You have to, let me just change slide. You have to first apply for the interim protection order before that protection order is made final. It's not something that happens automatically. So how can it happen? The Act now says that it is an ex parte application, which means it is one person. You don't need to inform the other person yet. that you want to apply for a protection order. You fill in certain forms. That's the Form 6. They've changed the form numbers, so just bear that in mind. Form 6 needs to be filled in, and that is an ex parte application on the prescribed form, and that needs to be lodged at the clerk of the court. The clerk of the court would take the matter, they would scrutinize it, they would put it on the electronic system, capture it on the electronic system, and then they would present that document, the application, they would present to the magistrate, probably in chambers, to look at your application. If it is urgent, if it's urgent applications, then that might be dealt after hours. The Act now specifically makes provision for after hours. Good luck to you guys wanting a magistrate to come out after hours, listening to a domestic violence order, even if it's just one of these normal Baarmoedervermaak matters. You know what? You're going to have the brunt of a magistrate at you. He or she is going to come down on a ton of bricks. But in serious instances where there's serious abuse and the application is necessary immediately because those people are in immediate danger, then the Act allows for after hours application for that. In terms of Section 4.2 of the Act, if a person is not legally represented, so they do not have an attorney present, then there's a duty upon the clerk of the court to inform them what is the relief available, how does it work, what do you need, and the clerk of the court also needs to tell them that they can apply for criminal charges being pressed for the offence that was committed. Section 4.3 and Section 4.4 of the Act was slightly amended, and it says that you can bring an application for a domestic violence protection interdict on behalf of somebody else. It need not be the complainant. It could be done on behalf of somebody else. Anyone that has a material interest, a vested material interest in the well-being of that person, can bring that application on behalf of somebody else, but with the written consent of that person. You need to have the written consent. I found that in many instances, we have mediators and we've got support systems from rape crisis and those people, social workers, getting involved with domestic violence cases. And then they assist the applicant in bringing such an application. And it's quite okay. It's quite okay for the social worker or the care worker at rape crisis or one of these NGOs to complete and to assist that complainant with the application form and to bring that application on their behalf. It's quite okay, but it needs to be done with the written consent of the people. The only exception is that if it is a child or a person that cannot consent. If a person is so beaten up and they basically in Ward 3, 5, 7, and 9 of the local Mediclinic, and they cannot apply, then somebody else, like a family member, could approach the court to bring such an application. Like I said, for Section 4.5, specifically deals with after hours submission of the application, only if harm will be suffered and it is not dealt with immediately. So there's a sense of urgency that needs to be addressed. Yes, there was a hand. Can you hear me? I'll take the questions later. Okay, thank you. Section 4, 6, and 7 deals with the affidavits and the capture thereof. That's basically just logistics on the side of DOJ, where supporting affidavits, where the clerk of the court needs to capture that on the systems, and they must. Then there's a provision in the Act that says it must be submitted to the court immediately. Now, immediately in your terms and immediately in my terms are two different things. If I want something immediately, then I want it now. Don't expect the same from court because you work with a process. One also needs to understand from a judicial point of view that the magistrates dealing with domestic violence matters do not only have one court. They might have the maintenance court. They might have a civil court. They might have the harassment court, the maintenance court. So they are busy with a host of other tasks. So the domestic violence, although it takes priority, and it's usually children's courts applications as well. It usually takes priority, but there's only so many hours in one day, and the magistrates cannot attend to everything. And although the provision in section 4, 6, and 7 is there, that the matter needs to be taken to the magistrate and it should be dealt with immediately, it is not always possible. It is not always possible. You cannot, I mean, it would be unreasonable for all of us sitting here, listening online, to expect a magistrate to drop everything because a simple application for domestic violence have come in. If there's urgency, I urge you guys to speak to the magistrate and tell them and explain that it is urgent, and then that the matter would be prioritized. But the normal palmoer for ma and chilling on a Sunday and then panel beating each other, yes, you know what, those type of applications are not deemed that urgent. And one has to bear in mind that the court rolls are overburdened with regards to applications that comes in. The Act now makes provision for the online submissions as mentioned in Section 4A. So you can submit your application to court for the application for domestic violence online. And there's the web link. There's the web link. It is found on the Department of Justice's website, where it says, and there's email addresses. Advocate Reuters actually gave the email addresses wrong. It starts off with capital letters DV and then the town's name at justice.gov.za. Those are the addresses, and that would go directly to the person dealing with that. We do have a couple of problems that we foresee with this because it's an unmanned email address at this stage. There's no protection mechanisms. If it was like one of my clerks, they would probably press the delete button if it comes through on a Friday and say, but oh, you never received it. Oh, it's a severe problem. Don't want to work. Susan, oh, it's never received that. So who's going to take control? Where's the checks and balances that's going to happen there? And that's something that needs to be addressed because we work with vulnerable people. We work with children. We work with elders. So we definitely need to address that as well. Just as a recap, who can apply for it? The complainant, child in care of the complainant, a functionary, that person that deals with the matter, if it's a social worker or psychologist, or any person that has a material interest in the well-being of the complainant with their consent. Of course, children can, without the consent of the parents, apply for a protection order as well. Where can you do that? It is done through the magistrate court. The clerks of the court will then accept it, and there is also the electronic means that you can submit your application, and directly to court if it is an application, an urgent application that you can do as well. So how do we do that? We fill in complete Form 2. That is actually wrong. It needs to be Form 6, together with supporting affidavits in terms of Section 5.4. You apply to court and you file your supplementary affidavits. I urge you guys dealing with, especially attorneys, mediators as well. If a client comes to you or the client phones you up and say, I want to open a case of domestic violence, or I'm already at court, ask them to hammagathle, just wait a couple of minutes. Because if they compile that affidavit, they compile that application right there and there, it is so emotionally ridden. It is from I've seen some of the applications, and it's a long sub story of how they feel. The courts don't work on feelings. Crimea River, the courts do not work with feelings. They work with facts. So if you take out all the fluff of the application form and you work with the facts, what the court would look at, then that's vastly different. So it's advisable that if a client comes to you, that as an attorney or as a mediator, that you assist them, even the social workers, then that you assist them in completing that form while they're of sober mind. Because they might remember, because now they are trauma-ridden. Once they stand at the court, they want the protection order now, and they don't know what to say. And the damn spaces on the form was only so little, and I want to talk a week about all the shit that I went through. And you can't fit it in 7 lines. You can't do that. Nothing prohibits you to file a supplementary affidavit. You can. So take some time. You want your application to be correct from the start, so that there's no need for the magistrate to postpone the matter again and again in order to get the information that is needed. So take some time. Write an affidavit. Write your whole story by means of an affidavit. Because remember now, the application would land on the desk of the magistrate. They don't know you are of a bar of a soap. They don't know who you are. So in order to bring them in the picture, to make them understand what you're going through, then that is advisable to do it in the form of an affidavit that you get attached to your application to make it more complete and to bring them in the picture. Please do not submit 103 pages of sob story, because then you'll aggravate the magistrate. They are biased people, but they do have a limit. It's very similar like applications in the High Court. If it's an urgent application in terms of Rule 43 and you submit 682 pages, if you had time to get 683 pages, then that is not considered to be urgent, because you had time to draft an affidavit and get supporting affidavits. Same with domestic violence. Duties of the clerk, I already mentioned that. Another thing that was brought into the new Act, and that was in Section 4A of the Act, is the Domestic Violence Safety Monitoring Notice. And that is something that they took over from a couple of countries that actually do that, if you do it comparatively towards other countries, and you look what other countries do. And that is where a complainant shares a joint residence with the respondent. Then that complainant can apply to court for the issuing of a domestic violence safety monitoring notice. What that basically means is that the court would look at the supporting affidavits where it was lodged, and the clerk of the court would actually take in the documents and then take it to the magistrate. The magistrate would listen to the matter. In terms of this domestic violence safety monitoring notice, the court may make an order to instruct in terms of Section 4A7 small a. Here we go with the numbers again. The court may make then an order instructing the SAP to contact the complainant at regular intervals by means of electronic service. We all know that as email or even WhatsApp, and to inquire about the complainant's well-being. So it's just basically a courtesy phone call or WhatsApp, you know what, are you okay? And that is in order to offer protection for people still staying in the same residence. If they moved out, if the respondent moved out, then you cannot make use of this domestic violence protection safety monitoring notice, because there's no need for it. It is only when the people are still staying together. The court can also make an order to enforce the SAP to go and visit the site, to go and visit the residence, to make sure that the woman or the lady is still okay. And then there is a provision in the law later on where it says that if the SAP is in fulfilling that obligation or the court order, if they are refused entry or prevented from seeing the complainant in order to find out if she is okay, then they could break down the door. Not quite into that terms, but yes, they can enter the joint residence and they can use as much force that is needed in order to gain entry, and probably including breaking down a door or a window of the residence, which was clearly mentioned there. That's just the instructions of the SAPS that I've mentioned. Now we come to a portion. Now we've finished with all the groundwork, and we've dealt with the application of the order in broad terms. Now we come to Section 5, which means that deals with the consideration of the application and the issuing of an interim protection order. Remember, I said that you can only go to court for an interim maintenance order or for a final order. And the final order will only be granted afterwards. Why? Why can't the court just dish out the court order? Why?
Because the other person also has a right to defend.
Perfect. They've got a right to be heard. Audi alteram partem rule in law. It says the other party needs to be heard. They need to be heard. Because you know what? People do lie. Contrary to popular belief, anything under oath is not always correct. Even if you say help me God, it's not always correct. So people do lie. And the other party, the respondent, needs to be afforded the opportunity to rebut and to ask questions and to say, but I do not agree with this, before such an invasive order as a domestic order is actually imposed upon a person. So in court, what would happen in court? Number one, you go to court, you fill in the application forms in terms of Section 4. The court then would grant the interim protection order and the Form 12 form. The form has also changed. If there is any act of domestic violence that has been committed, an undue hardship will be suffered by the complainant. So there should be some form of urgency. Then the court would grant an interim order. Now, what we see, what happens quite often, and that is fully understandable, is that the courts would use a RONIA form, a standardized form. If there's a domestic violence application, because they simply cannot just discharge thereof and say, but you know what, I'm not going to listen to it. It's a load of bull. They have to attend to it. So what courts would very often do is to grant the interim order, but make it a very broad order. And that could be the result of your application being so broad, not being detailed enough, that the magistrate could include things like economic relief, or dealing with care and contact of the children, refusal of seeing of the respondent of the children, and so forth. Those are all the symptoms of a very poorly drafted application form that needs to be dealt with, like I mentioned. So if you go to court, the court would grant you an interim order, but only if there was an act of domestic violence committed. Those definitions that we did, if any of those have been contravened, has been done by the perpetrator, by the respondent, yes, that would constitute a domestic violence offense that has been committed. But there's more. There should be undue hardship that needs to be suffered or will be suffered by the complainant in order for the court to grant an immediate interim protection order. That's in terms of Section 5.3. Section 5.4 says, and that was, if the magistrate is not sure, you know what, I'm not sure. It might be a shebeen fight at home or something like that. I don't know. It was the Sunday chilling time, and Dad had too many beer to drink, and then he decided to throw things around in house and do some paddle beating on the wife's face. And they're not sure if there was really an act of domestic violence that have been committed, or that there's undue hardship that might be suffered. Then the court would not grant the interim protection order, but they would give you a notice to show cause. The court would then say, I'm not going to grant you the order right now because I'm unsure. But in all fairness, and because it says so in the Act, but in all fairness, I'm going to give the respondent the opportunity to come to court, in terms of Section 5.4, to come to court and to tell me why I should not grant a protection order. And this is what is happening in most instances in our courts, where the magistrates, due to lack of a properly drafted application form, would rather opt to go for the Section 5.4 application form, where they do not grant the interim order, but rather to give out a notice to show cause. And then the service of the protection order, or the notice given for the respondent to appear, needs to be given to the respondent by the clerk of the court or the sheriff or the peace officer directed by court in terms of Section 13. Obviously, the complainant also needs to be notified of that address, because the complainant would simply go to court. They would hand in the application form. The matter would be given to the magistrate. The magistrate would look at the documents and then decide, in terms of Section 5.4, there's not enough grounds, but I'll issue a notice to appear. So by that time, the complainant would not know about the date. So the complainant also needs to be notified of that date in terms of section 5(7) by the clerk of the court. And then the return date must be at least 10 days after the service. So it's not a piece of paper that you can dish out now, you can ask for it now. There's a 10-day period that needs to lapse before you can return to court. Slightly amended, section 5, that deals with the consideration of the application and issuing of the protection order, the interim protection order. So what does the court need to look at before we get to that? And that has been slightly changed. And the only changes that was brought in there, apart from the fact that during this whole proceedings, that the family advocate could also be involved. The court could make a direction and order the family advocate, if there's a child that is in care of care and protection, then the court may order that the family advocate be appointed to look into this matter. The new act brought into this section 5, that a designated social worker could also be included in the proceedings. I've dealt with section 5 that deals with if the court does not issue a protection order, and then showing the cause, calling on the respondent to show cause on the return date. I've dealt that in the graphic. 10 days, I've dealt with that in the graphic as well. I'm only going to focus on the portions of the act that was severely changed. Section 5A was also changed, and that was brought in, and that dealt with the attendances of witnesses, and forms 14 and 15 is used for that. The court may then at any stage subpoena a person or any witness as a witness to testify or to provide a book or evidence or an object if the evidence of that person or the book is needed or essential as part of the decision for the case. And a person that has been subpoenaed in terms of this portion, section 5A, needs to be at court and can only be excused by the court in question. And if you fail to appear in court on the date of the subpoena, or am at court or is at court and then leave court without permission, you could be found guilty of an offence of a fine or 6 months imprisonment. Courts usually do not entertain this. They usually do not, only in very seldomly, they would give jail sentence or even a fine for witnesses. And I think that is also important that the judiciary note that in order not to frustrate the process, that they could use this portion, section 5A3, to give penalties for people not appearing at court giving testimony. Section 5B was included, like I said, that is dealing with the electronic service providers. That's the internet service providers. Those are the people that deals with, you log onto the internet, it might be a Vodacom, it might be Cape Connect, it might be any of those service providers. Now, those service providers, in terms of section 5B, could be forced by the court to divulge information about you as the account holder. If you received an email with some derogatory words or humiliating words, that constitutes an offence, abusive offence or abusive act, then the court may direct in terms of section 5B that all the credit providers, not the credit providers, the internet service providers, must make available the details of that person. Because everybody sending an email to somebody else does have an IP address. There's always a paper trail. If it's in cyberspace, there's always a paper trail. In order to circumvent that, in order to get that information before court, because otherwise the respondent could just turn around and say, but you know what, I did not send that. There's no proof thereof. In court, we only work with facts, not with feelings. And that is why section 5B was brought in. And there's a couple of severe penalties going with that as well. And I'll discuss that briefly at the penalty section that we'll deal in terms of section 17. They've got a certain number of days to give in the information. They can ask for extensions, But for all practical purposes, this would be a court process, and you as the layperson or even the attorney might not know or might not need this type of information in order to present your case.
On this from a legal point of view and possibly versus that you say the court may. You suggesting support. What happens if the parties require that information that you as subpoena produce?
Yes, you would probably do that. Yeah, you probably. Yes, but it should be the Act is very clear where it says that the court would make such a judgment call. So that the order for the direction in terms of Section 5B would come from the court. It would definitely have to go through the court in order to get the information from the service providers.
Right, so the one party would then address the court, say, I know this here.
Correct.
This between the parties, and the court could make
Correct. That is just for the people in the auditorium. That is the slide dealing with the electronic submissions or the electronic communications. This is a boring part. That's really boring. For our purposes, people sitting here, listening online, Section 5B, big B, 10, it says that the complainant, how unfair is that? The complainant is liable for the cost of the furnishing of the information. That's actually wrong. You approach the court for some assistance, some help, and now you could be slammed with a cost order. Fortunately, Section 11B then comes to your aid to say that the court might hold an inquiry into the means of the complainant if you cannot pay for that, and then make an order as it deems fit, including that the state pay for that. And I foresee that in most instances that this would be the case, because the people usually coming to domestic violence courts are usually not the people with the big bucks. Those are the people that really need it. Section 5C is a new section that was brought in, where it says that the court must, before they issue an interim protection order or a final order, must establish to find out if there's any other cases amongst or between the complainant or the respondent. These double ones, you know what? Hier is harregat, daar is harregat. So nou maak die sake te mekaar. That happens. It happens quite a lot. It's all about spitefulness, and then you know what? He sleeps in jail for the weekend, and dan het hy sy les geleer, and so forward, and so forth. Section 5C1 says that it's 5C2 rather says that if there are pending cases, the courts must order that both cases be dealt with together. So if you've got the dual applications, then both of those cases needs to be dealt with together. This creates a problem because in terms of Section 12, when we talk about the jurisdiction, the respondent can now, where he works or where he carries on business, he can apply there for a protection order. Mom can apply where she lives. So it might not be the same courts. So procedurally, it might cause difficulty. How would you get both those applications, and which court will hear those applications? I do not think the intention of the legislature was to say it was only matters in the one court. It is matters dealing with domestic violence of both parties. So DOJ definitely would have some work or some directives to this regard. What would happen? Are you going to look at who submitted it first, who was last, on the probability of convenience? What would be the situation in such an event? So what happens on the return date? Now you've got the interim protection order. Now you want, like I said, you've got the interim protection order, then you've got the final protection order. Don't think that only if you have the interim protection order that you're hunky-dory, because that order has only a limited period of a lifetime. What I mean by that, it's not like it's got a beginning and an end. It means that the interim order cannot go on forever. It needs to be converted to make it a final order. And the court needs to make it a final order to give you the full protection thereof. So in terms of Section 6, If we go to court and a Section 5.3 interim protection order was granted. Now, that is an order. Remember, the 5.3 application was an order where there was enough evidence and there was harm, and the court would feel and say, you know what, upon the evidence placed before me, because it's an ex parte application, with all the documents, with all the evidence that I have now, I will grant an interim protection order. That's the 5.3 order. So on the return date of the Section 5.3 order, where the magistrate made the order to give a protection order, if the respondent appears, the court will consider evidence. It will listen to testimony on affidavit or oral evidence. And if the court then is satisfied on the balance of probabilities that there was an act of domestic violence and that it is needed, then the court will make an order, a final order, in terms of Section 7.4. That's easy. That is, if the respondent appears in court, matter will be listened to, magistrate would make an order. Simple as that. Now we sit with a situation in terms of Section 6.1, waar die bliksem nie kom nie. They don't come. The respondent do not appear at court. So what happens then? Then the court needs to be satisfied that there was proper service, number one, that there's prima facie evidence of domestic violence in terms of Section 6.1, and only then the court will grant a final protection order. Two instances. If he appears, he will be listened to. If he does not appear and he had the opportunity and the magistrate was convinced that there was proper service, that he was notified thereof, and he had the opportunity to come to court, and he fails in doing so without any reasonable excuse, and there is prima facie evidence of abuse, then the magistrate will grant that final order. In the event, now, remember we said, okay, right, if the magistrate's sure, Section 5.3 comes into play, they give a interim protection order. If they're unsure and they give you a document to come to court at a later stage because they are uncertain in terms of Section 5.4, what would happen on that day? On that day, obviously, if the respondent appears, the court will consider the evidence either by testimony, orally, or by verbal written submissions. And if the court then is satisfied on the balance of probabilities that there's enough information granted or valid, then the court would grant a final protection order. If the respondent, and this is a new section that was brought in the Act, it was never in the previous Act. If the respondent does not appear when he needs to appear in terms of Section 6.1, the court must hear the matter. That is now if he does not appear. The court must hear the matter, and the court must be satisfied that there was proper service, prima facie evidence of domestic violence, and consider any other evidence. That could be evidence, you know what, it could be a social worker report. It could be from any of the NGOs. Any supporting documentation in terms of Section 6.1 big A the court needs to consider all those type of evidence in support for you to ask for the granting of a final protection order. And then the court must, in terms of Section 6.1 big A, B, again with a numbering, must make a final order. Issuing of the final order, we basically explained that. On the return date, now you would have the event where the respondent do not appear. But what happens if the complainant does not appear? Because that happens as well. She sent him to jail over the weekend, so I'd say less geleer, but he needs to clock into work on Wednesday because we want the team. That happens. It happens. So the complainant do not appear on the return date. So on the return date, in terms of Section 6, if the respondent appears, so that's the husband now, but the complainant is absent, or both of them are absent, then the court have to extend the date of the interim protection order and then notify the complainant to come to court. And only at the further extended date, only then, if the complainant is not there, then the court may discharge that order. Because then the complainant had two opportunities to come to court, to bring her matter before court, and then failed to appear. Where the magistrate did not grant the order right from the interim order from the get-go, but only did the order or the notice to appear, because they were uncertain. Let's talk about section 5.4 about the uncertain date. The uncertainty if it's really warranted or not issuing a interim protection order. So if the respondent there in that event appears and the complainant is absent, at that stage, the court may set either a new date or the court may discharge of the matter. And these were all provisions brought in by the new Act, which I firmly believe would streamline the process quite considerably. Advocate Reiters spoke about the evidence of intermediaries in terms of Section 51 of the Criminal Proceedings Act. I'm not going to deal with that. Safe to say that, yes, evidence through intermediaries are possible even in the domestic violence courts. As well as on the next slide, in terms of Section 51C, evidence is also possible through audiovisual link proceedings other than criminal proceedings. There is still, and the jury is still not out on this one, because the section deals with witnesses giving testimony through either the audiovisual link or through intermediaries. It is still not clear if that also would include the complainant. I firmly believe, and Dion is also one of the advocates thereof, that the complainant is actually a witness in her own case. So there would be no reason in the interest of justice for a witness or for the complainant to give testimony through the audiovisual link or through an intermediary. But there is, at this stage, there's no, because it's a new provision in law, at this stage, there's no case law with regards to that. So for how long after the court now has granted the final protection order, which was brought into the new portion of the Act, it says that a final protection order is issued and is of force in effect from the time of the existence and that the content of the order has been served upon the respondent. In the discussion papers leading up to the amendments, there was quite a number of talk. And there was quite a number of suggestions. On the one paper, they said from the date that the court put on the rubber stamp, that was the date that it was enforced. The other one said, no, you know what, at the stage when it comes to the knowledge of the respondent. So the legislator took them all together and they said, but you know what, that final court order, that final protection order is enforceable from the time of the existence and that the content of the order have been served on the respondent. We dealt with the Section A, the electronic integrated repository, not suppository, like I said previously. The court's powers that they could do, the powers of prohibition of certain acts has been amended, but not drastically. The normal ones are still there. The court may prohibit the respondent from committing or attempting to commit any act of domestic violence, enlisting the help of a third party to assist, or to enter a shared residence of the respondent or the complainant, entering a specific part of the house. These are all orders that the court could make in terms of the act. The new portion that was brought in is Section 7G big A, again with a numbering, is the disclosure of any electronic communication or making available any communication as may be specified. So the magistrate would very well could make an order prohibiting you from distributing emails or sending bogus emails or sending emails to anyone that might cause harm and contravene the court order. Section 7.2 mentions and said that the court then may impose any additional conditions which it deems necessary to protect and to provide the safety, health, and well-being of the complainant. So it's very broad for the magistrate, the powers that they could have in terms of Section 7. Section 7.2a, those are all the same. I'm not going to deal with them in detail. Something that might be important that we sometimes neglect is that the court may make an order in terms of Section 7.3, ordering a prohibition contemplated that the court may impose on the respondent an obligation to discharge rent or the mortgage bond payments having regard to the financial means of the complainant and the respondent. So what that basically means is that the respondent could be forced by a court order to keep on paying the rent or the mortgage payments, considering if he does have the means to do so. Section 4 that we also dealt with is the emergency monetary relief. Yes, it is enacted and it is in our court. That is in our act at this stage. It was something that was in the previous act. It was just extended. And the extension came in with the last portion. Let me just see. The last portion, which is Section B, where emergency monetary relief also means, apart from what you allowed, the loss of earnings, a contribution towards education, relocation, expenses for household necessities. Section B was brought in to say emergency monetary relief would also mean maintenance of a child, a person with disability, or an older person in care, in need of care of the complainant. So maintenance has been specifically mentioned in this portion of the Act in terms of Section 7.3, 7.4. Now, might we see a lot of applications running through the domestic violence court for maintenance? Surely, if you've got an attorney wise enough, you would to claim maintenance as an emergency monetary relief if there was circumstances that there were domestic violence acts done as well. So that very well. But would the one be substituted for the other one? I don't think so, although I foresee that there might be an influx of maintenance-related cases done through the domestic violence courts as well. Specifically for the communities, we are in South Africa. We all know that. And we have our own unique type of problems. And one of the problems that we have is drug dependency for the children out there, or for the fathers. And that creates a spiral of poverty, and it creates a whole grocery list of problems. And one of those things, like I mentioned, is the drug dependency, or even on alcohol. Section 7.4a was brought in to say that if the court is satisfied from the evidence that was led during this proceedings, that a person, the respondent, is probably a person mentioned in the Prevention and Treatment of Substance Abuse Act. With other words, he's got a problem with substance abuse. Then the court may request and direct that respondent to appear before an additional magistrate dealing with such type of matters for a Section 5 inquiry. That's an inquiry into the drug dependency. And if they do not appear on that date, then a warrant of arrest may be issued and he may be apprehended and be brought to court for the magistrate to hear the matter for him in terms of the Prevention and Treatment of the Substance Abuse Act. And that is brilliant. That is actually brilliant, because I think that would help the communities in solving drug-related problems and drug problems and this typical Sunday chill afternoon drinking sprees where most of the domestic violence is caused by alcohol or a dependency product. that they use. Details in terms of just some of the amendments. The physical home, study, and work address and the contact details of the complainant will not be appeared on the application form. There's no way that is specifically prohibited, as well as any details of a child. It is not supposed to be on the document. Section 7.6, which we see quite often being used by the courts, is with good reason, and that's all speaking to Section 28 of the Constitution that deals with the protection of children of the Constitution, where the court, if the court is then satisfied that it is in the best interest of the children, that the court may make an order that the respondent is refused contact with a child, or make any other order that the court may deem fit regarding to conditions that of supervision. And we usually see that with supervised visits and so forth. But that is something that the courts quite often use. In terms of Section 7.7, the court may not refuse an application or to issue a protection order or to impose any other condition just merely on grounds that other remedies are available. Say, for instance, the Maintenance Act is available, the court may not refuse to issue a protection order merely on grounds that there are other acts dealing with that as well. We come to warrant of arrests. Warrants of arrest upon issuing of a protection order. So whenever a court makes an order for a protection order, so you have the protection order, the court must make an order regarding the warrant of arrest. Because if you just have a protection order, what enforcement is there? There needs to be enforcement tools. So the courts they must, in terms of Section 8.1, they must issue a warrant of arrest, which is suspended on condition that the terms that the court might have said in terms of Section 7 is not contravened. And that warrant of arrest then remains in force unless it is set aside by a competent court or is cancelled after execution. Oh, this is a lovely portion. We spoke about the problems with the police. Yes. Section 8. Now you have the warrant of arrest. Mami het nou die papiere. So mami het die al die papiere. She's got the final order and she has the warrant of arrest. Now Papi is again on a Saturday or a Sunday chilling spree and he decides to panel beat her again. And now Mummy goes to the police station and she wants that enforced. So the problems that we have there with the police are numerous. We've got numerous, and obviously there needs to be discussions and some serious training with the SAPS regarding this. Because in terms of Section 8.4, if a complainant then hands in the warrant of arrest with an affidavit, that's a prescribed form, to the police station, and there are reasonable grounds to suspect that the complainant is suffering or may suffer harm. Now, this was the scapegoat of the police of not doing their jobs, and I call them out point blank, on air, in person, right here. Reasonable grounds to suspect that the complainant is suffering or may suffer harm. Under the previous act, it says the complainant should suffer imminent harm. So it's harm immediately.
Yes.
And then the police would say, you know what, you took 4 hours to get to the police station. There's no imminence. Needs not to be done now. And that was their backdoor. That was their reason what they used of not enforcing the warrants of arrest. Fortunately, under the new act, this amendment act, the word imminent was omitted. So it reads now that if there's reasonable grounds to suspect that the complainant is suffering or may suffer harm, No imminence. It's been taken out, which is brilliant. If, however, the SAPD feels in terms of section 8.4c that there's insufficient grounds for them to arrest in terms of the order, because remember now, mummy would go to the police station with a copy of the protection order as well as the original warrant of arrest, and the SAP then feels that there is not sufficient grounds to arrest, then they must immediately give the respondent notice to appear in court on a charge of committing the offence. So it's passed again to the courts to decide if there was any type of contravention. So how do the courts or the SAP, what are the trails of thought? Now, section 8 deals with, and it says, in considering whether a complainant is suffering or may suffer, remember now they took out the imminent, may suffer harm, the SAPS must take into account the risk to safety, health, or well-being, the seriousness of the conduct. That's in the old act, that stands as it was. The length of time since the alleged breach occurred. You can't go a week afterwards and say, but you know what, I was abused and I want the order enforced now, after a week's time. So they would look at the length of the time since the alleged breach of the order. And then what was brought into the act in terms of section D, it says that the nature and the extent of the harm previously suffered in the domestic relationship by the complainant or a related person should also be considered. And that's positive because the nature and extent of harm previously. So if you have this reoccurring theme of abuse, then the SAP, upon arresting a person on that warrant of execution, would become prevalent. This is just a graphic of normal how it would work. There's a violation of the protection, and that's just for clarification purposes, just to bring it all a little bit together. There would be a violation of the protection order. Complaint is then done to SAPS to report the breach. The complainant needs to complete the affidavit in Form 35 and submit Form 33, the original warrant, and a certified copy of the protection order, Form 12, 30, or 31. These forms are all available for download, and the download link is available. So then the SAP would have an opportunity. They would either arrest the person or they would warn the person to come to court. The matter would then be investigated, and there might be a decision to prosecute, and then there would the prosecution in terms of the criminal offence, in terms of section 17, would follow together with a formal trial. Seizure of weapons. Briefly, just we're nearing the end of this whole of what we're needing to deal with. In terms of weapons, and the definition of weapon has been extended. I'm not going into the definition. The only thing that I want to bring to your attention, because most of the people do have firearms. It is strange how many people in informal settlements actually own guns. It is scary. The Act now says that the court may make an order that the SAPS might seize that weapon, regardless of the requirements that the respondent needs that for his employment. Previously, this was not in the Act. And the comeback would be to say, but you know what, you cannot take my weapon because I am a police officer or I work in security. The Act now says, you know what, regardless of the requirement, if the respondent, in the respondent's employment requires them to carry a firearm. Also, if the respondent, the Act brought that in, if the respondent has threatened or expressed the intention to kill or injure themselves, again, coercive and controlling behavior, manipulation, yes. If they have threatened or expressed the intention to kill themselves or anybody else, then that would also constitute reasons for the seizure of the weapons. The courts would also look to the situation where the weapon is not in the best interest, or it's not in the best interest that the respondent should keep that weapon, specifically dealing with his state of mind or his mental condition. So if he's a little bit cuckoo or whatever, then that might be reasons for the police to remove that firearm because it might pose a threat. If the respondent has an inclination to violence or is dependent on drugs or alcohol, then that might be reasons for the refusal or the seizure of the weapons as well. Variations of the court order, that was basically the same. I'm not going through that. If you want the protection order to be amended, you need to give 10 days notice, and then the court must be satisfied that there was proper service and that there was good cause shown for the variation of that. Attendance of the people at court, I've briefly mentioned that. Many people don't know that you're allowed to have no more than 3 people for supporting the complainant. We don't see that happen quite often in the domestic violence courts because most courts would operate in camera and not allow any of those people being present in court for obvious reasons. Something that was brought in terms of section 11.2 was that no person's identity needs to be published directly or indirectly to reveal the identity of what happened in the domestic violence court. So there could be no talk about you could be found guilty of an offense if you divulge the names, the addresses, the names of the children, or the details of any party directly or indirectly involved in a domestic violence matter. And that could carry a criminal sanction of up to 2 years imprisonment. So that's actually a very stiff penalty. The only exception thereof would be the people doing the bona fide law reports, if they have to report on SAFLI or LexisNexis or Tutor or something like that they would be excluded. Jurisdiction, I've briefly mentioned that. The jurisdiction, the respondent, that included, the new act included that the respondent's permanent or temporary residency could also be used. And as well as where he studies, carries on business, or is employed. So it could very well happen that 2 different courts or more than 1 court could have jurisdiction in different matters. And it's specifically when it comes to cross applications, that it might happen in 1 court for the mother and in 1 court for the father, which might create problems because the act says that we need to deal with both applications at the same time. Cost orders, yes, lovely one. That wasn't been amended. Section 15, that was in the act, but it was slightly amended, that the court may make a cost order against any party, not just one or the other, any party, if it is satisfied that such party has acted frivolously, vexatiously, or unreasonably. So these moms opening up cases just to punish the dads, you might very well end up with a cost order, and vice versa. Offences, that's dealt with in section 17. Anyone contravening section 7, that is now the provisions of the protection order. If the magistrate said you should not do this, you can do this, you must not do that. First offense, 5 years imprisonment or a fine or both. So they increased that a little bit from 4, I think it was 4 years previously, to 5 years now. If it is a second offense, if he's found guilty of a second offense, the law now, the act now allows for 10 years imprisonment, which is quite a stiff sentence. Publication, like I mentioned in terms of section 11, publication of information to reveal the identity during court proceedings, you might see a prison sentence of up to 2 years. If you give false information, ladies, wanting to take revenge, listen. Section 8.4 says, if you give false information to have the respondent arrested, you could be fined for a first offense, a period of 2 years imprisonment, or a fine, or both. If you're found doing it again because you did not listen the first time, you could be found guilty of an offense to 4 years imprisonment. The others are basically the same. Reveal the identity. That is basically the offenses that we've dealt with. So what we've done now, just as a recap, we've basically now ran through all the definitions and all the workings, the ins and outs of the amended Domestic Violence Act. And that's basically concluding my portion. I'll have some closing remarks right at the end. I hope you guys are still all awake. I see a couple of them drifting off. Oh no, he might be praying, so let's leave him. So I'm going to hand over to my colleague now, and he's going to deal with the case law that deals with domestic violence. And these, especially for mediators, for attorneys, for advocates, this is where you can bring it all together to see, but how does it work in practice, what we've seen now with regards to the amendments. Thank you, guys.
Okay, I can see the volume and the energy levels are busy fading, so I'm rather going to use the microphone. I don't have the voice capacity of Eugene. So now you've got all of that. You understand all the things that Eugene spoke about. I think what's important is, I made a lot of copies, so let's quickly just run through it. Your application is the most important document that you need to know. How do you apply? Where do you apply? All of it. Look on page 80 of your handout. On page 80, you will see the application form that you need to complete. That is the new form that is out there. You don't have one. Is there one line here? That's a copy. Yeah. Is there extra copy that? Yes, there's a copy for you. So look at page 80. That is the new form that will be. That was form 2, is now form 6. So just make sure that you understand which form it is that you need to be able to get. Your application will then lead to an interim order. The interim order is on page 101. If you look on page 101, that is the interim order that you need to be able to get. I see this one is flat. Let me try the other one. The other one. All right, so page 101 is the interim order. That's the interim order that you need to get. After the interim order, whenever you have your interim order or your final order, always make sure, and the magistrates will make sure, that there is a warrant of arrest. Your warrant of arrest is on page 145. 145, so the magistrates must always make sure that when it's an interim order or their final order, there will be a warrant of arrest that will be issued, and that's on page 145. Do you see it? 145. So just make sure that when you leave that court, that you have an interim order. That was the old Form 8. The Form 8 is now Form 33. Make sure that, and tell the ladies that will come or come to you and say, no, I've got an order. Then you ask them, show me your Form 33. I want to see your Form 33. Then you know that the person knows what they're talking about, that they actually have an interim order in their possession. The interim order will be suspended. Suspended means it's not in operation. If he's going to not comply with whatever the order says, then obviously, Sadia, you're not getting it. Okay, don't worry. I'll make sure that I'll give you a copy where it is. And but 145, that's the interim order. That's your golden ticket that you need to make sure that you have that specific form. If you don't have it, then obviously you might run into trouble with the police, or when you get to the police is going to give you some problems. So I'd like to urge you, make sure that you have your interim order as well as your warrant of arrest. That was the old Form 8. It always goes hand in hand. That's why the case, there's this case, Omar versus government of RSA, dealing with that time was the Section 8 warrant of arrest. It's now the Form 33 warrant of arrest. what happened in this specific case. Mr. Omar was okay with the fact that interim order can be issued. No, it's okay. Give the interim order. Then he took the matter to the Pietermaritzburg High Court, and the Pietermaritzburg High Court found that actually this order can be issued because Mr. Omar said, no, but this is unfair. I didn't do anything. There's already a warrant of arrest out for me. And that was one of the biggest issues. Can a court issue an interim order with this Form 33? And the Supreme Court of Appeal in Bloemfontein found, yes, it can be done. The Supreme Court of Appeal in the Omar decision found that in that specific case, the Pietermaritzburg High Court decision, they confirmed that order. So always, when you have your interim order, there must always be a Form 33, page 145, make copies of it and tell the applicants or your family or your friends, if they say they went to the domestic violence court, ask where is that Form 33. It's important that they know that they get that document. If not, then obviously they might pick up problems when they get to the police station. The KS versus AM case dealt with the extension of Section 7.2. Now, what happened in this specific case of KS versus AM is the lady was in a relationship with the man, Mr. KS, or Mr. AM. Mr. AM was the male person, and she was in a relationship with him. Then Ms. KS found out that the person that she thought was only hers was not actually hers and was married, and then found out that he is actually he was married and in a relationship with somebody else. This lady came to her and said, "Where's my money? For my money." And because of that, Ms. KS then decided to end the relationship. And once she ended their relationship, Mr. AM came to her and told her that, no, you don't end it. I decide when is the end. It's not the end. And unfortunately, this is what happened. And in possession of Mr. KS were certain suggestive images that Ms. KS gave to Mr. AM during their relationship. And he every now and then will ask, "Sweetheart, you don't actually love me. Send me a picture of you half naked in the bathroom," and all of it. So all these suggestive pictures, Mr. KS requested from Ms. AM, and she sent these pictures. And when the relationship saw it, she asked, "Papa, please give my images back. I want all of it back." They didn't want to give it back, and then started to threaten her, and she went and applied for a domestic violence order at the court in Pietermaritzburg. Pietermaritzburg court then decided to give her the order. On the return date, she came back and she asked that, can we amend that order? Because Section 7.2 says you can do anything, the court can make extra conditions or put extra conditions. And one of the conditions that she put is she asked that the sheriff of the court look on his phone and do an audit and make sure all images are off his phone. She don't want anything to do with him. The Pietermaritzburg court initially found that, no, but we do not have the authority to go that far in making that type of order where you actually take the possession of the person. And obviously it was opposed on the fact that you are infringing in his, my phone, my phone. And that's what happened, what Mr. AM then said. The Pietermaritzburg High Court then, of the case went to the Supreme Court of Appeal. Supreme Court of Appeal said, no, the court have the inherent jurisdiction to make that order and order that the sheriff take that phone in possession and delete whatever images is on it. So if any of the parties over here, the young ones, are in a relationship with somebody and it's ours, please make sure that they can then do a audit and make sure all images are off their phones. If not, the Cybercrimes Act, look at the Cybercrimes Act. Now we have a new offense, revenge porn. So in a case where somebody create a Facebook page, like in Ms. AM's case, Ms. KS case, in that specific case, he went the extra step and he created a false Facebook page, and he put all of these images that she sent him, he put on Facebook as if it was her. Luckily, some of her family overseas saw these pictures and said, "Wat gaan aan? Why are you putting all of these images of you on Facebook?" She didn't do it, and then she asked that the court also make sure that Facebook page be closed down and all of the images to go off. Alternatively, the Cybercrimes Act is your way out. In terms of the Cybercrimes Act, which is in operation since last year now, you can then ask that that be done. We've got Magistrate De Silva over here. Yeah, that he did it. We do a course, the soccer unit do a course, a specialist course with the specialist prosecutors, where we show how it's been done and how we can actually show that it's him. We do a thing called cell phone mapping. We will pick up that cell phone. We can see with the email and HTML in which area the person was, and then we do cell phone mapping to see where that tower is that the cell phone got it from. We did it in the Marika de Klerk case, and we did it also in the Talib Peterson case, where we use that technology and we can pick up that email number. We will be able to pick up that it is the respondent that used the phone at a specific time. What we did in the Marika de Klerk case is we called, because the email number will give you all the numbers that was called. So we just called the most recent number and asked, "Listen, to whom did you speak?" "No, I spoke to the security guard that's working at Dolphin Beach." And that's how we found out that Marika de Klerk's phone was in the possession of the accused that then was found guilty. The same in the case of Ms. Najwa Peterson. Same thing, we could trace and find that she was at the airport and in contact with the accused 5, Mr. Hassan, and how she communicated with him. But there are ways that we will be able to find it. We've got I can be a little bit proud over here. The police have a specific unit called the Technical Support Unit, and we will be able to show that it is him that had access to the phone and where the HTML is registered. So that is clear over there, that there is ways that we can deal with that. So, Magistrate Silva, do you mind just stand so that the people see who you are, please? It's the first time I can order Magistrate. That is Magistrate De Silva, wonderful human being. She is in Stein Court, and she do beautiful work with the children. I always hear of all the wonderful things. If you can't get hold of me after the session, please speak to Ms. De Silva. She's an expert in the field of child law, and I always see in the Helderberg all the wonderful things that she is involved in. So please make use of her. In case you want to ask a burning question and you can't get to me, then please make sure that you get to Mr. Silva or Mr. Valley or Mr. Rocher. I will give him an opportunity also now to speak. So, but the most important thing you need to know is Facebook. If there are images of yours that you want to get off, there are ways. You report it to Facebook, and then from there onwards, if you want to file a case in terms of the Cybercrimes Act, there are ways that you will be able to then file a case in terms of the Cybercrimes Act. What I also want you to know is the NPA, the public prosecutors, we cannot withdraw. Section 18 of the Act is clear. We cannot just nilly-willy withdraw domestic violence matters. Now it's so serious that even if you come to a prosecutor and say you want to withdraw, prosecutor will be angry. So they will tell you straight off they don't want to, because our policy in part 28 of our policy is clear. We will not withdraw domestic violence matters. That is how serious these type of matters are that we are dealing with these days. So the Omar case, as I said, is Form 33. It is constitutional. Whenever you get a warrant of arrest or an interim order, your interim order always go with Form 33. Always make sure that you have that. Daffy versus Daffy, that dealt with a domestic relationship between two brothers. They had a company together, and this company was busy getting into financial difficulties because Mr. Daffy decided he's going to go to Qatar and have all these wonderful holidays wherever he felt like having a holiday. That's where he went. And the younger brother said, "Oh, listen, you can't be going up and down and just we're wasting money." And because of that, Mr. Daffy lost his employment in their joint company. And then after a while, there was some bad blood between the two brothers, and the one brother decided, "No, I'm going to file a domestic violence case against you. You can't do what you're doing." And in that specific court case, the court felt that a domestic relationship cannot go as far as a case where the two brothers are living far apart from one another. One is living in Swellendam, the one is living in Riversdale. They didn't live there, I'm just making an example. So go and look for who's Mr. Daffy. Don't do that. They are not there. I need to protect them, otherwise they're going to file a case against me. So all you need to know is domestic relationships cannot be where one person's living in another town and the other one in another town. But if there's a form of violence, then obviously then it will be possible for you to file it. There is, on the second page, you will see that there is some reading material that I also included that you can read. The one that I would like you to read is Professor Marnie's case in... It doesn't seem as if this thing wants to work now with me. But if you look at the next page, the next slide, Marnie's case, the limiting effect of Daffy versus Daffy. In the Professor Marnie's article, he says that it was a good opportunity for the courts to somehow extend the he's actually a little bit negative towards it because he looks at the New Zealand model. In New Zealand, they do allow it that you can get a protection order despite the two brothers living so far apart. In the South African context, we do not allow that. And Professor Marnie from UWC felt that in that specific case, we could have somehow extended it to be in line with the New Zealand legislation, but we in South Africa feel that it will take it a little bit too far in getting those type of orders. The Minister of Safety versus Venter case, in that specific case, went all the way to the Supreme Court of Appeal. Ms. Venter, or there were two Venters. The Venters were married, and then there were problems in their relationship. And while they were separated, they were not divorced yet, Ms. Venter moved into a house with another person. And these two, within a period of time, developed feelings for one another, and there was a relationship, despite Mr. Venter being somewhere else, and the two of them had split up. Then Mr. Venter found out that there's something going on between them, and he became jealous. And then he said, no, I don't have time for this nonsense. And I think it's time you come back and that we rekindle our relationship. And Ms. Venter moved on and said, no, I'm moving on. And she and a new partner, he was also in the police force, started to stay together and obviously have feelings for one another. Ms. Venter and a new partner then, because of a lot of threats that Mr. Venter made, decided that they are going to go and apply for a protection order at the court somewhere in Gauteng. I'm not going to mention where in Gauteng. But then they went, and when they got there, then the court did not want to issue didn't want to issue an interim protection order against them. After a lot of convincing, to the point where Ms. Venter had to go and call an attorney while she was at the domestic violence court. Only then they decide, okay, then let's just call him in and then see whether we can deal with it. During that period, the Miss Finter was at home alone one day, and Mr. Finter then said that there's a 4-year-old child that was also involved. I want to see my child. And because Miss Finter didn't want to somehow not allow the father-daughter relationship, she allowed the Mr. Finter into the house. When she allowed him in, then he said, "This is Judgment Day. Now I'm going to show you what I'm going to do." And the negative part is a gun was left outside. Miss Finter had a relationship with this man that was an ex-policeman. The ex-policeman had his gun outside, and this gun was lying there for her to use in case the Mr. Finter come there and wanted to hurt her. Mr. Finter found this gun and then said that now he is going to somehow use this gun. Miss Finter's mother usually have contact with her daughter during the day. And this day she didn't have any contact with her daughter at all. So she told Miss Finter's new partner, "Listen, there's something wrong. Please find out why my daughter's not calling or not in contact with me." Then what happened is the partner got to the house. When she got to the house, Miss Finter shouted from outside, "Run, get away from here," because he had the gun in his hand. The Mr. Finter started shooting and then ran out of the house. The partner ran down the road and there was shootings. It was cowboys and cokes over there. And eventually the security company that was in the area arrested Mr. Finter. And Mr. Finter was then locked up and in the police holding cells. But in that moment when he got access to the house and said it's Judgment Day, he told her, "Go and undress." So she had to undress and he raped her in the house. And then afterwards he threatened her what he's going to do to the children and all of those things, and that he's also going to kill himself. The sad part of it, he did commit suicide in the police holding cells. Miss Finter, as well as the partner, took this case and sued the Minister of Police, and they were successful in suing the Minister of Police. There's a principle that we attorneys and advocates work with in law called contributory negligence. And the court had to weigh who was negligent in this specific case. And because of the principle of contributory negligence, they found that the police were 85% negligent, 15% negligence was on the part of Miss Finter, allowing him into the house, and also the fact that the gun was left not in a safe but left outside, and therefore the court allocated 85% negligence to the police as well as 15% negligence to the Miss Finter. So that's one case that where the Minister of Safety and Security was sued successfully for failing in their duties to make sure that the warrant of the interim order is issued as well as a warrant of arrest is then issued. Another case in which they were successful is the Minister of Safety versus M. I put Uitenhage over there because I'm originally from Uitenhage in the Eastern Cape. They've got a new name for it, Kaiga. I don't like that name. It's still Uitenhage for me, so I'm still calling it Uitenhage. So now in Uitenhage, Mr. M was in his house, and Mrs. M was in Jeffreys Bay for the weekend, and she came back. When she came back, Mr. M was under the influence in his house in Uitenhage. And during the evening, when she came back from Jeffreys Bay, he became rowdy and he started to have sexual advances towards his wife and said that he wanted sex with her. During the evening, while she wanted to sleep, he kept on, sweetheart. And so she said, no, she's tired. She came from Jeffreys Bay. She do not have time for this now. And eventually it came to a point where she then had to call the police to somehow subdue him. When the police came there, Mr. M somehow fell asleep, and when he woke up, he was bare naked when the police came over there, and they said, put on clothes and all of it. And eventually the police arrested Mr. M, and he was locked up in the police holding cells in the Utenac. And then in terms of Section 50, subsection 6, you can keep, we as prosecutors can keep the accused in custody for up to 7 days at a time. So he was kept in custody for another 7 days. So, and on the date that of his bail application, that would have been the bail application, the prosecutors decided to withdraw. Mr. M then sued the police for unlawful arrest and said that in this specific case, what did I do wrong? Is it unlawful to be drunk in your own place? No, you can be under the influence at your place. The police said, no, but the lady told us that he's going to rape her, so therefore we were in our jurisdiction to arrest him. The advocate for Mr. M got an affidavit and asked Mrs. M, were you planning to file a rape case? No. Attempted rape? No. So therefore, there is no there is no lawful arrest, there is no incident of violence that were occurring, therefore there's no case. And in this specific case, Mr. M was lucky to get 15,000 rand for him for that 10 days that he was unlawfully then arrested. Another case is Mr. Katise's case. Mr. Katise was actually successful. He got 200,000, but the 200,000 were taken away by the when the case went to the Supreme Court of Appeal, because in Mr. Katise's case, they found that Mr. Katise, while the police were on the scene, he assaulted the survivor, the applicant, in his presence. And because he committed an act in front of the police, therefore there is an incident of violence, even though it was initially that he was successful in getting the award for unlawful arrest. The fact that he committed an offense in the presence of the police, the Supreme Court of Appeal felt there was an act of violence. Therefore, the 200,000 that was given to him, the Supreme Court of Appeal took away. And also he didn't appear or he didn't oppose the appeal when it went to the Supreme Court of Appeal in Bloemfontein. So therefore, it was allowed in that specific case. It's difficult for the police to make a decision where they're going to move with these cases. It's such a thin line between arrest or not arrest, and the police need to make sure that they will do a lawful arrest within the ambit of the domestic violence legislation. But it's so difficult these days, especially when it comes to bail. As I said to you, Section 11 and Section 59 of the 59 capital A of the Criminal Procedure Act have been changed now. There's no such thing as after hour bail and all of those kind of things. If you're in custody till the court see you. And the magistrate or the prosecutor must give reasons why you want to release. It's not just, your worship, you can go on bail, it's all right. Come on bail, it's all right. No, it's not going to work like that anymore. Whenever an accused is in custody, the police, even if the prosecutor is not going to object to it, they must give reasons why they are not objecting to it. And the court must issue and say why that specific person is being released, even if the prosecutor is not going to object to it. And there's no such thing as Schedule 7 after hour bail. If a person is released on a 496 or whatever the case is, in that specific case, and I will let my learned colleague get an opportunity to just explain that this is what will happen. A magistrate, when they find that an accused was 496, that means that he was released on police bail. The magistrate will say, no, there's no such thing as police bail, and he will be arrested and be put in their court holding cells, and she or he will have to conduct a bail application and decide whether he should get bail, even where the police made a mistake. They cannot just say, oh, okay, they made a mistake, so all right, they cannot stay a blind eye. I must maybe a blind eye to this thing, but They cannot stay a blind eye to these type of offenses. They need to act in the best interest of that individual. In Atlantis, Mr. Archer, can you just come up here so that everyone can hear? An incident happened similar to what I described now. And luckily, Mr. Rochette explained that to me. He's an attorney, a colleague of mine. And he was sitting in court when this actually happened. So I thought it was good so that you can hear it from the horse's mouth, that it's not me just saying it, and this is actually what happened in Atlantis court.
Thank you. Hi, good day, everyone. Thank you, Mr. Advocate Reiters. Yeah, I just thought it's important in this forum, whilst we're discussing the amendments to the Domestic Violence Act, that we should actually also explain the other practical side to, and more in particular, the effect of the amendments to the Criminal Matters Amendment Act. Because there's another way of also getting a Domestic Violence Act, and it's related to what Advocate Reiters was now alluded to. And the situation is now with the amendments to the Criminal Matters Amendment Act and the Domestic Violence Act is that if, let's say, wifey phones the police, the man is busy, my husband is busy assaulting me or the children in the house, please come and arrest him. If the police is satisfied that there was a criminal act of domestic violence committed, the police must arrest. That offender can then not be released on police bail, Section 59, or on a warning by the police. He or she needs to be kept in custody and appear in court, and will only be released on bail if the court is satisfied that he can be released on bail. So that is the effect of the amendment to the criminal, or imposed now by the Criminal Matters Amendment Act. Right? That's important. Number two is the situation that Mr. Advocate Reiters was alluding to is the following. So I was some 2 weeks ago, also not knowing that the act came into operation. I was sitting in Atlantis court and I was waiting for my matter to be called. Actually, I was busy in B court and I had to rush to A court, so I was sitting quietly where the lawyers normally sit in front of court. So up, the prosecutor then calls the next matter, and the gentleman was appearing from the holding cells at court, what we refer to as a gat. So he was then called up, and the prosecutor informed the magistrate, Ms. Mangai, who I actually have very huge respect for, and said that he's before court because he has assaulted his daughter. So the magistrate said, is the daughter present in court? Because of the amendments now imposed by the Criminal Matters Amendment Act, she was duty bound to conduct an inquiry. So the complainant in the criminal case was asked to take the stand, and she was asked whether she wants to apply for domestic violence, for protection order under the Domestic Violence Act, because she's entitled to that, obviously, if the court is so satisfied. And she said yes, took the stand, she said yes, so the magistrate then conducted the inquiry. And in those instances, the court grants you a final protection order if they satisfy there are grounds for such an order. So that was the first incident. So the matter that the prosecutor then called up immediately after that matter is someone appearing from the court building, from outside the court hall. And the magistrate said to her, but this matter seems to be identical to the previous one. So why is he coming from outside and not from the gat af? She says, no, the police released him on a 496, in other words, on a warning. The magistrate says, no, but there's inconsistency, and I'm duty bound by this recent amendments to instruct the court orderly to arrest him. So he must go. He's on a warning, but he was then arrested, taken down to the holding cells, and then later on, obviously in the day, he was going to be called back for him to do a formal bail application. All right? So the courts take this very seriously, but I think the lesson to be learned also is that there's another way of also getting a final protection order, if there are obviously grounds for it. We've now heard we can't now lay false charges, there's criminal penalties for that. But the other important thing is that if a complainant has laid a criminal complaint of domestic violence and the offender was arrested, the complainant must make sure that she's at court on the day of the first appearance, so that the court can then do that inquiry and then he or she can then, the complainant can then get, if there are sufficient grounds, the court is so satisfied, get a final protection order. So I thought it was important just to say those practical insights with the audience here as well.
If it is assigned protection order, and then 496 that is to feel no longer right? Then that means they're not talking to the
Yeah, let me,
what section do you use as an application to have custody? Because obviously they were looking for the people for the
yeah. Okay, maybe I must just backtrack a little bit. So this was a incident where there was no protection order at all in place, right? Not an interim or a final protection order. It was a normal case of domestic violence perpetrated. The one case was against the adult daughter. The second one involved the wife, all right? So that's number one. Number two is, and to answer you, where the offender was released on a warning by the police and brought in that way, in other words, before court, the magistrate now with the amendments to these two acts had the power to order for him to be arrested. Because remember, he was supposed to be kept in custody. He was not supposed, in the first place, to be released on a police warning.
So then in procedure, you were either not placed the matter in jail 15, or it was still placed on the road.
Are you talking now from a prosecutor point of view? I think you mustn't place it on the roll because he's not properly then. Mr. Reuters, I don't know. You the prosecutor. I remember I'm a defense attorney. Thank you.
Thank you. That's Mr. Elton Rashid. So based on what he is saying, that the magistrate said that in that specific case, this person goes back into the court made that order and told that he will be arrested by the police. He was arrested, and then again, you will then appear before the court. So do not waste time by now first withdrawing and then rearresting him and then do all of that. Just let the police, the court orderly arrest him and then follow due process in terms of the Amendment Act. And you can tell the court that he was incorrectly 496 being warned by the police, and therefore that's the reason why. So in any case where you find that a person have been undue or wrongly being released on bail or whatever the case might be, speak to the prosecutor and tell the prosecutor this is what is supposed to happen. The court needs to do a full inquiry. And the nice thing about the Amendment Act now is that whenever the court finds out during the bail application, but this is a domestic relationship, there's a domestic relationship between the parties, the court can immediately call the complainant and tell the complainant, please come to court and then testify for the court. That's the reason why it is a final order. There's no need for an interim order now because it's there. Both of them are there, so there's no need for an interim order. These type of nitty-gritties is what we need to start engaging in so that all of us now know and all the online people are knowing that this is the way we're supposed to deal with it. Mr. Elton Rashid, thank you so much for coming and sharing that with us. We really appreciate it. And there are more of these type of examples that we need to share amongst one another as we go on dealing with these type of cases. I just want to quickly deal with the other matters or the other cases. Is that slide moving there? Okay, let me quickly, I already spoke about the Katise matter. Nadine versus Anders dealt with the position of where there are children involved and the father want to use the fact that he can't have access to his child as a basis for him to say that he is emotionally or being abused. I want to see my child, I can't see my child. All of those type of things, it was then discussed in Nadine versus Anders. And the court do have the authority then to limit his right of access and all of those, even though he's got Section 18 of the Children's Act, parental rights, all of those rights can then be limited in terms of the case law that's out there. And that's why I requested that we speak about mediation, because some of these cases are going to clog the court hole. Because a lot of these men are going to come up with this thing, I'm emotionally abused, which is going to somehow lead to our court halls being overloaded. There was a case last year, also in the Western Cape High Court, dealing with the issue of consistent SMSs, where our judges over here decided that if there is no element of violence, then there is no protection order that can be granted. Because luckily in the case they did say there, even though there are good intentions with the domestic violence legislation, there will be abuse in the process, abuse by both parties, the applicant as well as the respondent. And that is what happened in some of the other case law that we didn't cover in today's session. The Lalatu case, State versus Lalatu 2005, the Eastern Cape case. Whenever a lady have a domestic violence order, and once she have this order stating that the accused do not come to her property, then she calls him and tell him, sweetheart, come over, bring some money with you. And he comes over. And then she asked, now, where's the money? She says, I don't have money, don't have anything, but you said I must come, so I came. And then he says, what, no money? What are you doing here? I've got a protection order that states that you shouldn't be here. In a case where a person applies for a protection order and then consent to something that's in a protection order, it negates that validity of the order. And what happened to poor Ms. Lalatu? The court found him guilty for non-compliance to the order, because the court just stated at, this is the order, you didn't comply with it, you're a big man, you should know that you're not supposed to be there. But in this specific Eastern Cape case, the Eastern Cape High Court found that where a person, an applicant applies for an order and she doesn't comply with that provisions herself by giving permission for him to do what she asked him not to do, there's no way he can be found guilty. So luckily, Mr. Slalatu, I know I'm not pronouncing it right, but he was then given an opportunity to be, or he was released, and the court then, the High Court, the Eastern Cape High Court, found him not guilty, even though he was found guilty in the quota quo. The quota quo found that in that specific case, he was guilty because he didn't comply with the order, even though poor Mr. Lalatu said, yeah, but she said I must come, so what must I now do if she says I must come? And in those specific cases, the court should take in consideration, even there is non-compliance with the order, then the court is supposed to do that. In the Moshari case in the Northern Cape, something similar happened. We don't have enough time. It is in your package. Please read it whenever you get an opportunity. I just want to quickly go back to the Criminal Law Amendment Act 12 of 2021. Please note, anything pertaining to domestic violence in the legislation now says that we should take that serious. Section 59A, there's no more police bail. There's no more 496s. They cannot do that. If they do it, there will be consequences to it. In the event where the person is then in front of court afterwards, then the court will then have to deal with it and then issue a final protection order if it comes down to it. Minimum sentences legislation. The minimum sentence legislation in the regional court says that when an accused commit a murder and during the trial they find out there was a domestic relationship between the deceased and the accused, then that will be aggravating circumstances that now warrants life imprisonment. If the deceased in that specific case had a protection order against that person, then in those cases, the court can now, in terms of the Criminal Law Amendment Act 12 of 2021, in that specific case, impose life imprisonment in cases like that. The other life imprisonment is also in the case of rape, where it is obviously a life imprisonment of rape of a minor person under the age of 16. If it's a gang rape, all of those still stand. The ones that are added, if the rape is committed against an elderly person, in terms of a person, an elderly is a person over the age of 60, in terms of the Older Persons Act definition, Section 1 of the Older Persons Act definition says any person over the age of 60 is regarded as an elderly person. I know Mr. Hugo's now going to say the Older Persons Amendment Act is not in operation yet. I know that. There is a difference in the act the way it is now. There is two differentiations. A female person turns an elderly at the age of 60, a male person at the age of 65 in terms of the Older Persons Act. But there is an amendment that will be coming in operation any day now. So I'll just pray and hope that it's within the next week. Otherwise, Mr. Eagle's going to keep on saying that's wrong, that's wrong. I know it's wrong, but the Older Persons Act is going to be brought in line with the SASA Act. The SASA Act is already, the Social Assistance Act already say both male and female at the age of 60 will be able to have access to it. But all you need to know is, in the case of rape of an elderly person, life imprisonment. In the case of rape of, if there's a protection order and the accused committed rape against the survivor, I don't want to call them victims, Ms. Naomi Batana is going to kick my head off, survivor. So in a case where the survivor then file a case of rape and it comes out during the trial that actually there was an incident of domestic violence in the rape or part of the rape, then obviously the court can impose life imprisonment. I'll get you now. So in all of those cases, then the court can impose life imprisonment. There's also a part 4 of the minimum sentences legislation where there is a minimum sentence of 10 years imprisonment that can be ordered by the court in a case of assault of a person that have a domestic violence order or is in a domestic relationship. The court, in terms of the minimum sentences legislation, will see that as an aggravating circumstance why the court should then have a more serious or more heftier penalty that the court can impose. Bail legislation, you have got some idea, the sentencing that the courts can impose. There's even in the case of the parole board now, a provision that when it comes to the parole board and there was domestic relationship, then the survivor can go and testify and say how she feels about this person being released on parole in that specific case. Mr. Arons is looking at me. I thought it's only my wife, but I see Mr. Arons also picked up on this. Maybe the two were sitting over there at the back. I see they picked up. Also, it's saying, where's the question? So we will give you an opportunity, or we will give an opportunity for questions. I will let our MC get the questions, and then Mr. Eugene and Mr. Eugene Opperman and I will answer the questions. And I think our MC also had something else that you want to say. So please come to the fore, and then we will get an opportunity for questions. I will speak to Mr. Rashid while our MC take with that. I will get to you, but I will give Mr. Eugene Opperman and myself an opportunity just to have closing arguments, and then we will still allow whoever is over here and want to ask questions, you will be able to ask those questions. Over to you, Mr. Opperman.
Yes, we're nearing the end. It was an absolute phenomenal day. I checked some of the stats on my phone of all these streaming platforms, and at one stage we were more than 2,000 people online. That just shows you the enormous impact that we do have here and how needed it is. On your question with regards to SAPS, I just want to mention in terms of Section 18, it is, I think it's 18B, it is specifically mentioned that if the SAP do not comply with the national orders, then they can be kept held liable and be guilty of contempt and misuse. and there could be serious implications for them. Another question that just came out that I did not address because it was still part of the old act is the question of how long is a interim or a protection order valid? No one asked that, or someone asked me that in the break quickly, and I forget to mention that because it was in the old act. The protection order is valid for how long? Up until it is valid up until the time that a court discharges or varies that order. So that order stands up until the time that it is varied or discharged by a court, by a valid court, and the operation thereof is right throughout South Africa. So you can enforce that all over South Africa. If you go to the police station, you have your final protection order, and you enforce that because you have to give them the original, in terms of Section 8, you have to give them the original warrant of arrest. They will take that to court, which means that you are left without a warrant. Then you can apply for a second and a subsequent warrant from the clerk of the court. That is basically my presentation for the day. It was quite interesting. I urge you guys to become involved. I also mentioned online for the viewers online is that please do send me an email on info@lunchandlearn.org.za. explaining a little bit about your institution, that you represent, your NGO, your law firm, together with some contact details, and you can even add in your logo as well. Send me an email, just a little write-up of your history and everything, and we'll compile for all the attendees right here a type of and I'll do that probably within the next 2 weeks. We'll do a type of a newsletter just to see who's who, and then there might be networking opportunities and referral opportunities of, I didn't know about that person, but I could use that person, because we're all like-minded people. Please do send me that. That's basically what I conclude. Thank you so much for Natalie and for Dion for their presentations as well. I started off with some hypnosis. Let's just start off with, we'll end it off because there might be people that are asleep. So put out your hands like that. Everybody, bring it a little bit closer. Thank you, guys.